Yes. Give all the memos. Please give all the memos. Let us first give all the memos. Just wait. Are you in hurry?
Two times never.
Are you in hurry? Just wait.
Two times never is the.
Yes.
The date is given, but the delegation not sending the file.
Why? The seat.
I have written to the deputy register, but despite
Why it has
the
been-
file
it has not been
sending the
sent.
file to the lease section.
Ask. Yes. What do you want?
Honestly,
My secret is supposed to he has sustained the motive individual. They for
Who is for the other side?
a senior resident.
Who is for the other side?
Maternity.
Is the personal difficulty.
Yes.
2 weeks?
3 weeks.
3 weeks. 37.
Item 21. Item 21. It's a state of it. Here, the registered companies need to be added as a parties because they were parties before the executing court.
You have to have the respondent. I oppose it because they have this. Yes, a lot of because the matter will be disposed today. The party which is seeking to add, they have already executed the conveyance, and your lordship has kept this for disposal.
Sir, a party has to be added provided he is a necessary. If he was a party in a proceeding, if by one reason or another he is left out, where is the difficulty on the part of the court to bring him on record?
All I
Sorry?
let it be called up.
Let it be called. No difficulty. It will be called, but the party, if he was a party, then he should be added. We will exercise our suo motu power under Order 1 Rule 10(2).
Let it be not.
Yes, let us see. Don't worry.
8, my lord. That is the tender matter. The lordship was kept to today for the prayer of the government site. It will be taken up today because last date is tomorrow is the last date for submission.
Let us see.
Okay, my lord.
Pardon me, I have a difficult prayer, my lord. I must confess, but my difficulty is on my part is, my lord, I'm constrained to make it on item number 44. Just a short for a minute. I am a tender, I've got the LOI, I've paid the money.
What you will do, let us see if we can reach.
My lord, my entire point is that it has been stayed behind my back, so I filed an idea.
So whatever the vacation of the interim order, you have filed an application vacating, we'll consider it, don't worry.
If not today, my lord, let me lodge it.
Whatever, let us see if you restrict your argument to only 2 minutes, I will be happy.
I'll do so, my lord.
Yes.
I'll take it.
But
Deeply obliged.
15 matters where writ appeals, we have filed already the IA application to withdraw those writ appeals because in the meantime it has been decided to please. I'll give the numbers for
Correct.
today. I will give the numbers.
For judgment item number 1, WPC 19752 of 2025.
Consequence of our observations made very critical sans merit is dismissed when pending until the applications shall also be dismissed accordingly. In the circumstances, there shall be no order as to property.
Yes. Call the next.
Press admission item number 2.
Representation to be considered.
Directly to take instruction in the matter. Unless what is there, my lord, has to be this.
This is what.
Happy.
Yes.
Well, I need to take the complete instruction. But we'll take up matter tomorrow.
What?
I will take complete instruction because the instruction I have received that is not.
This is relating to a release of the money.
No, ma'am. Related to without floating to tender matter, my lord, the 9 courts somewhat on splitting matter they have got. And
Without floating a tender,
without floating a tender, my lord, they have got devised.
For the credit to meet the
within the
limits,
correct.
pecuniary limits.
Yes.
By forfeit.
No, I understand.
Tomorrow.
Tomorrow.
Item number 3.
State already filed counter, copy not sought to me now.
Not served.
Yes, no.
Affidavit dated 37/2025.
Is the affidavit submitted by the Tahsildar?
You have filed your affidavit or counter what?
Affidavit.
Yes. This is 29/7. The state files an affidavit.
Item number 4.
We have a senior study and Masama, I pay 1 week of adjournment.
Is he?
Senior advocate, they should, you have power there? No. What is your name?
Name is.
Give him.
At the request
1
of-
week or 2 weeks?
1 week.
Item number 5.
Please, your lordship. On dated 23rd July 2025, your lordship, I directed to the State Council to create instruction regarding the matter.
You've already filed a counter affidavit yesterday, Your Lordship.
What?
You filed
Copy
a
served.
counter affidavit.
Copy served.
Counsel files copy served in open court. Would you like to file rejoinder?
My lord.
2 weeks, rejoinder in the meantime.
If any.
No, that is what is said.
Item number 6.
Read this question. Establishment of a public health center at another place. No, it was sanctioned by the government to establish it at Chittal, which is the village of the petitioner.
Whether the sanction was accorded at a particular place.
What should be filing the counter affidavit right now? I can serve an advance copy.
Advance copy. In course of this day,
Because right now, your lordship can see.
in course of this one. Rejoinder, if any, you can file within 2 weeks.
Next week.
2 weeks.
Item number 7.
I'm appearing on behalf of the petitioner. On the previous occasion,
Just. Have you taken instruction whether those relationship certificates were submitted by them? Submitted.
And in the meantime, we have to watch it very common.
Show us, give us the documents, what? Show us that they submitted. Your affidavit must come. That was our order. If it is filed along with this, he has no case.
That is the only grievance you raised.
Yes, yes, that is the
That
only.
is the only grievance which
Yes,
you
sir.
have raised, but they have not enclosed those documents along with the
Tender.
tender.
the language which is used is creating, you are just playing trick. I think the officer who has signed it is playing trick. Superintendent engineer. Read the language which he has used. Structure. That comparative chart valid. If it's 3 or 4.
4, Your Worship.
Shows valid.
Yes, sir.
Where is the relationship certificate issued by all 4?
Well, I have
You are playing trick. Our specific instruction was that whoever has been declared, their documents are valid, whether they submitted the relationship certificate. You have very cunningly, may I use the word, stated that at least the successful bidder has submitted the relationship certificate. What about the others? If others have not, then they are also disqualified and single bid. Will you continue? Read your language. Paragraph 2 and 3. I have not seen the documents, but I have seen your amendments.
wrong word.
It's not a wrong wording. Not a wrong wording. That shows that he is trying to play tricks. What affidavit? Then we are staying everything. Don't release the payment. What is this? If they want to play trick, then we know how to tackle these kind of
Wrong wording.
may I use the word recalcitrant authority.
Wrong wording.
We know how to tackle them.
Second one.
Don't try to play. Let the message go that they are not supposed to play with the juggleries of the words. No, what affidavit? We will not. He simply wanted the disclosure. One line would have been sufficient that all the success, the bidders who qualified in a technical submitted the relationship certificate, not an its.
Well, actually, these 3 bidders have succeeded in the technical.
Where you have stated?
No,
Where you have stated, tell me. Simply said that the successful bidder who has been allotted a work submitted the relationship certificate. He is the only person out of 4 who submitted. Then other 3 bids should be cancelled. If ultimately only one bidder is there in the financial bid stage, what he will do? Award the contract or not award the contract?
3 bidders, they have submitted.
Where you have stated the 3 bidders?
Well, the successful bidders, namely Home Engineering, RG Enterprises, and Kishore Kumar Behra.
Sir, come to serial number 4. Page 102.
Well, see, Jagannath.
Where is this?
Huh? What is the word? Successful bidder, such and such in relationship submitted.
That's the wrong word. Well,
Yes.
Madam, let's kindly have a glance
No, no.
page 137, madam.
The document speaks for.
Page 137. For a moment, sir.
This is by enterprises.
I think that is from the.
And then the software with us, who is
That's the given.
Get 137, another Kishore Kumar Behra. These are the three persons who have given the negotiations.
And one is already there in the record. 137.
Your Lordship,
Records are there.
Your Lordship, they didn't answer the question that was it submitted along with the tender?
Yes,
That is their document.
yes. Yes.
Your Lordship, I have the each step to acquire the documents, Your Lordship. They must have submitted physically, Your Lordship, which is not allowed, Your Lordship. According to,
These are all curable deeds.
but it should be submitted online. Point number, Your Lordship. Your Lordship, page number
The work
29.
is also complete.
Your Lordship, page number 29, the 3.1. Your Lordship.
Be happy. There must be a limit of an interval.
But Your Lordship, I have step by step.
Well, maybe you want an affidavit, want the litigations to continue or, and then if they give an affidavit saying that it is there, then we will deal with it. That if somebody comes with a false statement, then what should be done?
Yes, Your Lordship, because in the portal, it is controlled by center, Your Lordship.
Sorry, if there is any fault in the portal, we go by. Yes. We
Item number 8.
Ten days time will be given to file counter. We've already discussed counters and it is timely. The department needs to approve it, your options. Another 10 days to.
Reproduction has been allowed.
So not.
No, this was, no, I did not find, I was looking at it because my principle is if it is a second extension, then some cost. But I do not find there is any direction for filing. Only thing is instruction.
Instruction.
The officer concerned had.
The respondent is directed to file counter affidavit within 14 days. Semicolon.
Item 9.
Item 9, last occasion I took time to take instruction. We have not received instruction. Also may give for them more time, 2 weeks time. Either from DUPT and also the Army Tribunal says, Army Welfare Society will give the instruction.
On 2 earlier occasions that was adjourned on the ground that took.
Yes, I have taken time, I am meeting, man.
So 16/7, 23/7, then how long will it continue?
Another 2 weeks time, maybe let's may give a last chance, otherwise let's may pass this.
This is not, if the authorities are so reluctant, then it is better let them.
So I am telling my lord, last chance may be given, otherwise I will not stand on the way.
Lordship, the recruitment process is prima facie illegal. It needs to be stopped at this point of time. It needs to be stayed.
Look at it. He is renewing the prayer for entry order.
Yes.
Seeing the urgency only, your Lordship, sir, directed for the instruction.
Or Lordship may fix it the next week also. Next week. We'll take a last chance, otherwise. It's a policy decision of the government of India. That's why I'm directing the DPT circular, which was challenged by my lord, and there should be.
Prima facie, the recruitment was to be conducted by UPSC.
Because it is a all India impact.
CAT
That's why I'm
itself
pressing.
is conducting the recruitment.
Oh.
The prima facie, the recruitment process is illegal because it was to be conducted by UPSC. CAT itself is conducting the recruitment.
CAT means?
Central Administrative Tribunal. So lots of
After the Tribunal Reforms Act, I think there has come in 1921 or 2021 or 2022.
That is regarding chairperson and members. This
and
is
here?
Subordinate staff.
Okay. Subordinate staff will be conducted by the UPSC.
Yes, your lordship. If your lordships may come to page 91, this is already in Annexure 5, page 91. This is office memorandum of DOPT of 1989.
Yes.
May I place it, your lordship?
89, the tribunal was established or much after?
This was regarding the deputation in all the central government establishments. Presently, CAT itself is conducting the recruitment.
No. There must be a sanctioned post when a tribunal is established under Article 323 capital A of the Constitution. Then it has got an independent status under the Constitution, and then the supporting staff and everything, there must be a sanctioned strength of that. And if they have taken up the recruitment drive to fill up those sanctioned posts, why you talk about the deputation? Why you talk about the deputation? It's a question of filling up of the post.
Yes, lordship.
So
the recruitment of a section officer is by deputation only.
Where is the rule which says that it can only be done? Where is a CAT rule or a service rule which says that it is only by deputation, it cannot be filled up by a regular drive?
Annex 7, page 152 units.
Yes.
Annexus 7, page
Yes.
152. This is CAT recruitment rule.
Yes, I just wanted to look at that. Yes, show us.
30th April.
This is a group B or group C?
There are different posts, not
All,
group B.
all are combined. Yes, then?
I need a lot. Deputation or absorption?
No, I'm just talking method of recruitment. I'm just talking about what is the method of. There may be the provision relating to deputation. There is no doubt about it. But I'm talking about the recruitment, how it is to be done.
That is at page 151, column number 10. You know. Method of recruiting. 50% by promotion, failing which by deputation, 50% by deputation.
No, just where it at?
It's at page 151. Center right side.
Section officer. Which one?
Section officer.
Sixes. Or the court officers?
Section officer. Section officer or court officer?
Just 1 minute. Yes, then?
Column 10 says 50% by promotion, failing which by deputation, and 50% by deputation
or absorption. Correct.
According to this recruitment rule, CAT published the recruitment at Annexus 16, page 206. That is the advertisement.
Just 1 minute. That's on a deputation basis.
That's on a deputation basis.
Correct. So,
but if I take your lordships to Annexus 5, the original page 91, which was the composite method of recruitment by deputation. And Annexus 5 says if there is a composite method of recruitment, the recruitment will be done by UPSC only.
Sir, this is of 1989. Sir, when the Central Administrative Tribunal was established, when it was established, I think at 1989 it did not cease its birth. I believe so.
The lordships, the DOPT memorandum.
I am asking when a DOPT, when there was no occasion for any tribunalization, I think the tribunalization happened much after.
Yes, Your Lordship. But our case is
notified.
But it was established much after.
Our case is, Your Lordships, for ex-servicemen, deputation is to be provided for each and every services. That was a 85 and 86 memorandum, Annexure 3 and 4. That is not being complied by DOPT. And CAT comes under DOPT only.
No, which is there? The officers placing eligibility. That's a registrar. We are not concerned with the registrar. Where is a section officer? Section officer rule 6.
Lordships, may kindly peruse Annexure 4, page 86. This is a memorandum for DOPT.
So they have said that there are vacancies are there and the person working under the central government, state government, high court, subordinate courts, holding the analogous posts, they may be absorbed on deputation.
But in 86 memorandum, Your Lordships, DOPT says that in each and every recruitment rule at column 10 and 11, transfer and deputation.
When the CAT was established here in the state of Odisha, I have an idea of some other state which I know much after that. But what is the scenario here?
It's very initial period, probably in 85, along with the principal bench.
Is the clue? Establishment to get it.
Lordships, in 86, DOPT says in all the recruitment in central government, a clause in column 10 for a re-employment of ex-serviceman needs to be put.
Sir,
And that is
ex-serv-
not been complied with by any of the department of the government. And CAT is not complying. The recruitment rule itself is wrong without column 10 being implemented for ex-servicemen.
And this act of administrative, Tribunals Act, when it came?
1980.
No, date. Administrative Tribunal Act. February 27th.
It is showing the 27 February 1985.
No, 27th February.
Yes,
I was
yes, madam.
looking at
Yes,
this date because this is also of 1985, but it's 31st May 1985. I was checking up that.
Yes.
So this is what it says, that so far as the ex-army men are concerned, they may be also given an opportunity in a civil post, either on deputation or by way of a re-employment.
Yes, sir.
So
That
So
needs
there is already, I think it's a horizontal representation, there's reservation which is to be followed,
that is not being followed by
is not followed
No.
means, it's an open one.
that is our case, Your Lordship. That 86 memorandum needs to be implemented in each and every recruitment rules of the central government. And in 89, the deputation process is again enumerated by the DOPT, which says where there is a composite method of recruitment, UPSC will conduct the recruitment. But here in this case, CAT is conducting the recruitment without amending the recruitment rule.
There is no recruitment rules in that regard where it says UPSC has to be done. Where it says the UPSC will do,
1989, page 91, Your Lordships. Subpara 3.3.
I'm still unable to understand what you are arguing.
May I explain 1 minute?
Unable to, because creating lot of confusions.
My apology, Your Lordships.
But let me read where it says.
Page 91.
I am at page 88, Office Memorandum of 3rd October 1989.
Yes, Your Lordship. That is the procedure to be followed in cases where appointment is to be made by transfer and deputation.
Yes.
This is a memo.
This is not a case of a transfer, it is simply a case of a deputation or re-employment.
Yes, Your Lordship.
This is what one has to understand.
Deputation itself is a transfer and deputation. Any central government to central government is
It's not in that sense a transfer. Is only a stopgap measure for a particular limited period
yes.
to avail the services from the officer of the another department. That's a temporary measure, unless they wanted to regularly absorb, because he keep his lien in the parent department,
That is
entitled to promotion in the parent department as well.
That is what is 86 memorandum says.
Sir, that is what is to be. Yes, and it's a lateral induction.
Yes, sir. Then at page 91, para 3 is consultation with Union Public Service Commission, and 3.3 is what we are relying upon.
It is a group C post,
Group B post.
Group B.
gazetted. Group B.
B,
B.
B. B for Bangalore.
Yes, sir.
Where? Which you wanted to come under clause 3? Which one? 3.3 or 3.2 or 3.1? 3.1 does not apply.
Yes, sir.
3.2 also does not apply.
3.3.
3.3 does not talk about this. The composite, it says the composite method of the recruitment for both the group A and group B is 1. Then it is to be consulted and is to be made by the officer because of the reasons of 3.1 and 3.2.
Yes, your lordships, but
Is a composite one. If they really wanted only a group B, then
they're clarifying that if the departmental candidate is to be considered along with the outsider, then in this recruitment rule, the state.
where is the consideration of the outsiders?
That is in the recruitment rule itself.
It does not talk about, it says simply promotion and on deputation. It does not talk about the fresh employment.
At next page, at page 152, it says about deputation in itself. And that is what is inducted in the advertisement.
What page?
152.
What?
52.
What is that?
That is the deputation or absorption. Persons working under central government or state government or high court or subordinate court. So the departmental candidates will be considered along with the state government and high court staff. Then this provision itself makes it a composite method of recruitment.
No, composite method of recruitment of group A and group B. You are probably, we are not at one. Composite method, when it used in 3.3, relates to an appointment or recruitment of group A and group B together.
Yes, your lordship.
So this is, where is that? It is only restricted to group B.
But in the advertisement, they have advertised for group A and B, but in different columns.
That is a separate one. If a composite method, but the method is not a composite one. It's a different one.
B is separately and A is separately.
Absolutely.
Yes, your lord.
So,
but in the advertisement, they have only made the single advertisement.
What it says 3.3, a file now to bare Java is very difficult one. What it says is,
it reads all.
When a composite method of recruitment, one has to understand the process of recruitment is prescribed for A and B.
This is or.
That is what?
Or
group B. That is, the departmental candidate is to be considered along with outsiders. Here is not an outsider. Outsider would mean who is neither in a government role or anybody. This is directly from the public.
But that cannot be a deputation post.
That is what I'm saying. It is applicable when it is where on a deputation or by a regular employment. Means inviting the peoples from the open field to apply, both.
That will be a direct recruitment.
No. It says that we can fill up. There are many posts which requires not only filling up by an outsider, but also by a deputation and the promotion. So sometimes there are 2-3 methods in the service jurisprudence. One is that they can divide the total number of the post in 2 categories, saying say, for example, I'm not saying so, say, for example, 50% shall be filled up by a promotion and 50% by a direct recruitment. Correct. There are other posts which says that 50% will be by promotion and the 50% by deputation. There is no open because of the specialized category of the services which they want to take advantage. So those who are already in government service, rendering this their services to the government, they can be taken out for a temporary period, and then the provision for absorption is also there. If they opt that they wanted to be absorbed here, then the permission from the parent department and the absorption can be done. This is what is a fundamental and basic principles of this. Understood something different.
Lordships are correct.
Correctly. If I'm wrong, I'm still open to correct myself.
Lordships are absolutely correct, but this.
Yes, it's by way of deputation or by way of a
Promotion.
That's it. So it is not that whoever all other country will make. The question was along with the outsider. You say the departmental candidate. Who is the departmental candidate?
Only who is
coming from a department. It may be from a transport department to a finance department. Somebody may come from the department of the child and the women social welfare department to another department, public health and engineering department. These are all departmental transfer.
Yes, Lordships, but the inclusion of state government
means anybody from the different organizations. What is the different organizations? The organization is that from a central government or from a state government.
State government.
If they wanted to take it into a central government deputy. So in our, I think all the court staffs are known that there are judicial officers who are the state cadre judicial officers of the state of Orissa. They have been taken to a central as a registrar of the Supreme Court. How can they go?
Composite deputation.
How can they go?
Deputation.
UPSC has done. Never. Never. I will be happy because I will get those back. So that their services can be availed of.
Lordships, this memorandum speaks of only deputation.
Well, it can't be. That's why I'm saying on deputation means that their services are spared for a very limited people. But they still hold the parent post. They are entitled to promotion in the parent post, in a parent card of the parent organization. Will not be regarded as the employee or the officer of the deputation department.
That the memorandum speaks at introduction, Your Lordship.
Never.
For
Never on deputation. What you are talking about that was
but ex-servicemen will observe.
UPSC. I will be very happy if one has to hold UPSC. But these officers, the Group A and Group B, they have already crossed the civil services examination of the state. They have to undergo another examination.
No, this is not open competitive exam.
When you talk about the UPSC, then they will have to, there may be 50 persons on deputation from different departments. Amongst them, only one post is to be filled. How? How you will identify the the suitability or the best candidate? Some exercise has to be done.
Yes, sir.
What UPSC will do? Interview. Not permissible. The Tribunal says can't be. Simple interview is not permissible. Then a written examination. What? Why?
That is another memorandum. I presently I don't have that in memorandum, but it says that UPSC can resort to any of the
It's to be judged by a department who wanted somebody to come and work on the petition.
Yes, your lordship, I am not being allowed.
One minute I can understand where you have for the first time you are making an entry and then the department will definitely nurture them. Nobody comes with all the knowledge and the experience of working in a particular department. They gain experience and the knowledge when they enter by passage of time.
Yes, your lordship.
On the day one when they started the practice, he knew everything. I knew. I was absolutely educated on many things. By passage of time, after looking the surroundings, something a little one, I claim to have a little one. Everybody learns that one. Yet the definition wanted a seasoned person, so that seamless working.
Yes, your lordship, my case is that 86 memorandum says ex-servicemen will be considered, but in the recruitment rule and in the advertisement.
Because there should be some kind of a reservation that is reservation in case of a recruitment. Reservation when we talk about, they can offer.
They're not considering me, your lordship.
Offer. But you wanted a horizontal reservations in case of a deputation.
No reservation, your lordship. I need only consideration for the post.
Definitely, everybody can apply.
I'm not being allowed to apply, your lordships. That is my case. That 86 memorandum says in column 10 they have to
allow him for admission. Mr. DSG, he is entitled to offer his candidature. There is no difficulty. He wanted to go on deputation. That you can't deny. But a reservation, I have some doubts on deputation too. Recruitment, I know. There should be a horizontal reservation for the ex-serviceman.
But Lakshmi, see that the same page 89.
That was apprehension.
So it is not now. There is no provision for lateral induction by the application.
Yes. You have relied upon a judgment which is not applicable.
The caption heading of a petition you have brought to our notice that WPC 1388 of 2022 so and so was filed, but you have not stated that it has already been disposed of.
Lordships, on that order, your lordship had directed to take instruction for the very first time.
This is the order.
And goes against your submission. You are relying on this judgment and it goes against your submission.
That I have annexed at Annex 12, your lordship.
Sir.
Page 181 is the relevant portion of this order. Lordships have asked for the instruction from the very first day on the basis of this order only. That 86 memorandum needs to be incorporated in all the recruitment rules. So that I can be allowed for deputation in any of the government services.
So based on this 2007 memorandum.
86 memorandum.
This is a 2007 memorandum is considered there.
5.
Paragraph 5.
Page 180 of your.
Anyhow, we do not intend to go deep. We are prima facie, we are not satisfied with.
Mr. Pari.
Mr. Pari, you
Yes, ma'am.
take instruction, but one
Yes.
thing which emerged and which I also feel, this is tentative, obviously. We have
My lord.
not framed our mind into this, that you can't deprive somebody else who is in the armed forces to offer his candidature for deputation.
That's true, my lord, but
It should be open and it should be followed. You can't. Whether he's suitable or not is another factor.
aspect, yes.
There's another factor. But you can't deprive.
Page 178.
So you take instruction. We are not.
Yes, my lord. Yes,
doing
my lord.
more. But we are fixing this matter in the next week on next Friday, the Wednesday.
After 10 days, any date, lordship.
No, next Wednesday. You come.
Let me fix. Yes. I will try to get it. Yes.
As a last chance, let this let this matter be adjourned till the Wednesday to enable the learned DSG to take instruction. But
I'm satisfied, lots of.
whatever. Very difficult propositions, huh?
On Wednesday, I'll try to
So
satisfy.
after 2007, what is the position?
Lots of, that time I was a lower division clerk, now I'm a group B officer.
And because they have brought forward
Any other further amendment has been
or
brought.
office memorandum, there may be in tune with this. This may be group C and group D. So your claim is with regard to group B.
Group B gazetted.
So there may be possibility that they have brought in tune with that 2007 office memorandum. We do not know. You check up.
Yes, sir. I will check it.
Let them come. Yes.
Item 10.
Next. 10.
Just remind my lords about the last order, 23/7/2025, order number 1. My elected Mrs. Patnaik hearing, she wanted some instruction in the matter.
File the counter affidavit immediately.
It is not uploaded now, this order.
I've got the order. It's uploaded.
No. I mean, it is not coming to me. Oh, yes, now it has come.
They accept the file the counter affidavit and submit the.
Fact not required. But then still she hides it.
Why you deprive your brethren fraternity?
Now they have activated LMS
Yes.
in full-fledged manner.
Yes. And very proud in filing counters also.
That's good for them, no?
Right.
But a very casual way, may I say, of drafting the counter. If we go by a strict rule of pleadings, I think these are all coming under the doctrine of non-travels. Or your affidavit, you are keeping eyes closed for some reason, for only ends of justice. That is, otherwise, all your counter affidavits are silent on the abhorrence of the allegation made in the petition. You have not dealt with. Either you have expressed, you have to deny, or you have to partially accept.
Yes.
You have to say no abhorrence. That in relation to the paragraph 2 of the petition, I'll say this. You simply take a parawise comment and then do it. No dealing of each of the allegations which are there. If there is no denial, then
Non-travels.
non-travels.
Recent judgment has also come up. Not many judgments, sir.
Sometimes the lordship becomes very bulky, so we put in one clause that anything that has not been specifically admitted is denied.
Dispense with the requirement of law. No, you can't. I'm not applying strict rules of order 8.
Yes, not specifically denied shall be deemed to be admitted.
Evasive denial, then the
Evasive denial.
not specifically denied, not dealt with. What is the consequences? Be careful. Otherwise, I do not know who will take.
I clear my. But on the last topic, the losses are usually.
That you have revoked the suspension. You are suspension.
Yes.
Yesterday. That is, the petition has been filed purely based on certain newspaper publications. But this is the specific instruction which I have received from the government. The government of Orissa in food and supplies Survey has not issued any office order or instructions to suspend the ration entitlements for approximately 20.5 lakh beneficiaries.
He has not suspended.
My Lord, no, kindly. This is notification which has come after I filed the writ petition matter. Here, they are proposing the amendments as reported and which are very disturbing your lordship. I need your lordship's indulgence to amend the petition to challenge some of the amendments in this, your lordship. My lord,
What are those amendments?
My lord, the third page, there are two complaints, but the main one is the third. Your lordship, page number 3, point number 3 as well. My lord, by way of amendment, what they are proposing to do is very.
They wanted to certain insertion of certain subclause.
My lord.
What are
Which would very substantively affect the act itself. 22, the state may read from 3 itself. In the said order, in clause 4, after subclause 21, the following subclauses shall be inserted, namely, the state government shall temporarily disable ration cards of beneficiaries who haven't used their entitlements in the last 6 months. Thereafter, the state government shall conduct e-KYC by conducting field verification within the next 3 months to re-evaluate the ration card, determine eligibility, and take appropriate action. My lord, this
a wonderful way of filtration. Are you not, if you do not operate your bank account for a particular period, are they not declaring that account as a government?
I bought.
The moment it is government, then you have to approach the bank, give a KYC, give everything, and they will make it an activity. They are also. What they have said that the ration is a periodical one. You have to go and collect the ration either on a monthly basis or on a quarterly basis, whatever, or on a fortnightly basis. It all depends upon the scheme policy. One is state to another. If what they say that if you do not lift the ration for 6 months continuously, then in that event it will be temporarily disabled. Then you have to go and say that first thing is this is my KYC and all everything I have here. There may be a reason that why you are not lifting.
Mine,
There are certain good persons,
mine,
very, I would say, the very responsible citizen of the country. Because the rationing is for for a particular section of the society.
mine.
If somebody has elevated his status and he does not meet those requirements, then it is better that you should surrender that particular ration. So that another beneficiary may be included
Right.
here. So what is the wrong with it?
That's what. That's what. And like what your lordship observed is absolutely correct. In an ideal situation, as your lordship gave the example of bank, it is absolutely fine. But on the last occasion, as I had humbly pleaded that in this state, in this country, your lordship, there is a PIL that is under your lordship's jurisdiction, wherein the mandate that the ration has to be supplied to the needy people is not yet fulfilled, your lordship. There are people.
That is the lapses because
That is what happening.
It should reach to each and every section of the society
Minor.
who are
eligible.
under the who are
That is what
coming under that particular.
Minor.
That is what is the process of implementation.
Minor.
But how can we declare
That is what
constitutional?
That is what is related, your lordship. That's what I'm trying to explain, your lordship. If the ration is not reached to the people and they're unable to collect it for longer period of time.
No, that is not.
And that context they will disable.
Please, what they say is that it shall temporarily disable. Sorry, it shall temporarily disable ration card of the beneficiary who have not used their entitlement.
Minor.
So, question of user.
Minor.
If they are prevented from using, then it will not apply.
That is the point that needs.
No.
That is the point that should clarify.
Cannot. That's why we are here.
Minor.
You are here.
Yes, minor. That's what I made up.
That's why you are here.
Minor. That the previous amendment.
No.
Just the previous amendment. The proposed previous amendment actually takes care of this issue that your lordship is raising. That ineligible people should be weeded out and eligible people should be included. That is taken care of under the amendment 2. Now this one is, my lord, is problematic.
Then 23, we are 22, we are not.
And 23 is that talks about duplication of cards.
Definitely.
That is
nobody can.
I do not dispute that. Only 22 would be very problematic because
you challenge that the people saying.
And that's what I was saying.
That will not take much time to decide.
Right.
2020. That will be why it is.
Right.
Pursuant to the order dated
illegal construction of Anganwadi center, sub-center in a government occupied building, PWD, occupied by the PWD department. And
I could not get it, what you said.
my lord, the petitioner challenged the illegal construction already taken up. Illegally construction of a building meant for the functioning of Anganwadi center. Anganwadi center inside the campus of a PWD offices. One side the PWD office campus. Inside the PWD office, public works department store offices.
It is used, if they wanted to use a particular surplus land.
No, my lord.
Why there is?
My lord, there is no surplus land.
What are you talking?
Four Anganwadi centers, my lord.
By your affidavit, what is this?
Unless notice is to go to Soro municipality, the primary answer.
Notice issued on other home.
Lord, opposite party number 13, Soro municipality.
And you are representing?
Lord, the rest of all the opposite rest of the opposite parties.
Keep notice and affidavit by the other, the appearing.
My lord, here, my lord, I have challenged the annexure 10 order, my lord. It's concerning a tender, my lord, of veterinary medicines. 27/2020 veterinary supply of veterinary medicines tender, my lord. Your lordships, today's, my lord, item number 48. Your lordships have delivered it upon, my lord, and I am told, my lord, counter affidavit was filed by the state. But here, my lord, I have taken some more grounds, my lord.
Can you multiply the litigation by taking more?
No, my lord, because my lord, we both, my lord, the petitioner in item number 48 and I, my lord.
Then
Was
let it be tagged with the item number 48.
My lord, my lord.
All these tenders sorry, pertains to procurement of animal medicines, veterinary medicines. Lordship may kindly appreciate.
These are essential.
Essential.
There is no doubt.
Your Lordship, what they are doing, two writ petitions, Your Lordship, coordinate bench, two divisional benches have already dismissed. They are challenging an essential eligibility clause, which is basically a public policy. Your Lordship knows the settled principle in law of contract. So what they are doing, one after another, I do not know, notwithstanding the non-fulfillment of the eligibility criteria, they have been knocking at Your Lordship's door so that the tender would be delayed. Now, because of the fraud in some of the area, we are not even able to supply the animal medicine. So Your Lordship may take it up. The other day it was hard, my Lord's sister wanted some accommodation. Otherwise, if any interim order, I don't think it is there.
No, there is
so, that is
there cannot be any interim order.
I am never prayed for any
So
interim.
Your Lordship may clarify.
My lord,
My lord,
it's not been properly.
They want to take it from a particular
Yes. My lord, they are not doing it properly.
How much 3 years they have essential service went by
Petitions by the coordinate bench have
My lord, the first writ application filed in January, my lord.
That is a different ground, my lord. But I am ready to do.
The eligibility criteria, what will be the eligibility?
Both the matters be taken up today, my lord. We'll address your lordship.
That cannot be preceded because, my lord, that's
item 13 is the same petition. 13 is the same petition.
That is the
abuse. My lord, I'll show to your lordships, my lord, the first advertisement which was there in January, my lord, has been stayed by this honorable court and no action has been taken.
Two judgments. The principle is same. One is medicine, one is your lordship. The winner pharma and this what is the mayor agencies. The two judgments of two different benches. Your lordship may kindly look at the abuse of the process. It is a tender matter, public policy. What would be the eligibility criteria which is best suited? Because somebody doesn't fulfill the criteria, he comes and challenges. Jagdish Mandal, Tata Cellular, series of judgments.
We are following those judgments.
High Court also on the infra. The courts are
the criteria are tailor-made. That is my ground, my lord.
These are cases.
Your Lordship may take it up, my lord, for final hearing. We are
Yeah,
placing the
please.
matter.
My lord, in similar case, Supreme Court now dismissed that this is the
Same one.
my lord, one of the bidder went to Supreme Court.
Tender law is very clear.
I will place, my lord, that judgment has no application to the facts of the present case, my lord. Because the first medicine tender, my lord, has been stayed since January 2025, my lord. No action has been taken by the government.
Your Lordship knows the scope of judicial review in contract matters. Is same matter, same eligibility. Sorry. Right. The same petitioner. We will have started. The first one. Now it's under the penalty.
My lord, so far as my case is concerned, my lord, kindly come to page 13.
What are you challenging? You are challenging the.
Well, I am challenging, my lord, the impugned order passed by the government, by the director, my lord, annexure 10.
That is the whole problem with the virtual hearing. You do not listen, you do not respond.
My lord,
Please, let us see your prayer first. You are challenging a particular impugned order dated 2/7/2025 by opposite party number 2. Now, that is an annexure 10.
Yes, my lord.
Yes, what it says.
Annexure 10, my lord, was passed by the opposite party number 2, rejecting my claim, my lord, for change of these provisions and to have a fresh tender in terms of OGFR provisions.
Okay. What are the problems which you say? What changes?
But if you also look at my prayer portion, I'm sorry, my lord, I'm in VC because of my illness, my lord. Kindly come to page 23, my lord.
I'm looking at page 23, one after. You are challenging an order dated 2/7/2025.
My lord.
Which is annexure 10.
My lord.
As illegal to what extent?
Illegal, my lord. The provision of the OGFR says, my lord, there is a conflict of interest has to be disclosed by each of the bidders.
What
Here, my lord,
conflict of interest? What do you mean by the word conflict of interest?
My lord, kindly come to page 13, my lord. I have highlighted the OGFR provision.
I am simply asking you what is a conflict of interest?
Conflict of interest, my lord. My lord, conflict of interest directly or indirectly control if the two bidders are directly or indirectly controlled or controlled by on the common control with another bidder. Here, my lord,
Why you say that they are controlling? Let us see.
My lord, because they are.
What are the grounds or what are the facts which you perceived in this regard? Tell us.
My lord, I have been saying, my lord, if your lordship look at that, my lord, I have highlighted in para 23, my lord. Para
What
20,
is the
my lord,
meaning
page
of
17. My lord, both the bidders, my lord, they are son and mother of one family.
Son and
mother.
My
lord. And they have been dealing with both the categories, my lord. One is veterinary medicines, another is equipment, my lord. Since 2015.
Yes.
And for last 3 years, from 2020, my lord, there was no tender.
Sir, if you look at the language, if both the mother and son are dealing with the same thing in the tender, means the veterinary medicine, then I can understand. If they are into a different zone, one supplies the veterinary medicines, other supplies the veterinary equipments.
My lord.
Can you satisfy this definition? Any bidder having a conflict of interest which substantially affects the fair competition shall not be eligible to bid in this tender.
Yes,
which is restricted whether both have applied for veterinary medicine.
Yes, my lord. Both of them have applied, my lord, in 2025 January tender and also, my lord, in May tender.
Sir,
and both
January tender was restricted to what?
Restricted to medicine, my lord. And that has been stayed by the Honorable Court.
Then?
And thereafter, my lord, the fresh tender of medicine was issued in 8/5/2025.
Correct.
That was the subject matter of challenge, my lord.
Have they both applied? Whether both applied?
Yes, my lord. That's why, my lord, I have made them as opposite party because in the bidding process, my lord, the pre-bid meeting, my lord, I could know that they are also participant in particular bidder.
Yes.
And that's why, my lord, I have made them as opposite parties.
Correct.
Seeing, my lord,
so they have already said clause 3.4.
My lord.
is a conflict of interest. Then what is this? Then
conflict of interest. And my lord, I have given documents, my lord, under annexure 18 series. Kindly come to page 207. This is, my lord, with reference to equipment and articles, my lord. My lord, kindly see the manner in which, my lord, both the bidders have been selected, and 8 of the, my lord, kindly come to page 209. There are 10 bidders participated. My lord, kindly come to page 209.
yes.
10 have been participated. Only, my lord, except those two, my lord, opposite part number 3 and 4, all of them have been rejected. My lord, and the rejection ground, my lord, that your lordship will get it.
Where are you?
My lord, I was
In
not
10?
there, my lord. That's why, my lord, I have approached.
Where are you within 10? Sir, where are you within 10?
I was not allowed to participate, my lord. That's why, my lord, I have filed 2 separate applications, which is pending, my lord, where interim orders have been passed.
What interim
Any
order
action
to permit you to participate?
No, they have not allowed us, my lord.
Only
They have
if
not
you are
allowed
not
us.
eligible, if you are not eligible, then
My
you
lord.
have to. They will take care. Whatever,
My lord,
they will take a decision.
My lord, just kindly see, my lord, page 213, my lord. Dealing with
I have
public
seen
tender, my
page
lord.
207. I have seen page 209. Now I am going to page 213. Tell me.
Yes, my lord. My lord, kindly see, all are big farmhouse manufacturers and of national repute, my lord.
Correct.
My lord, all of them have their tenders have been rejected. As if, my lord, they have filed that tender to get those tenders bids
Sir,
rejected.
these are rejected on the ground of non-compliance of certain conditions. If they are aggrieved, they will definitely approach the court.
Well, they have not approached, my lord. That's why, my lord,
That is the whole
there's a
thing.
tender
Are you
reading.
saying then what nexus?
My lord?
Then you'll have to establish the nexus.
My lord, nexus means
They are under the pervasive control of the supplier.
Well, I'll just I understand my
One stage you say that they are the big manufacturer of the country.
My lord.
Then?
My lord, kindly see, my lord, the parties. My lord, it is, my lord, kindly see those 10 bidders, my lord. This is from different states. And they do not know, my lord, the requirement of having a GST in Orissa. They do not have they have no idea, my lord, how to get their bids filed.
Sir,
All
they
of
are
them have
such
been
a
rejected on the
beginner. Sir, what are you talking about, sir? A person who is a big business house. They do not know how to participate in a tender. This is
exactly,
what
that
we
is my
have to
question, my lord.
accept. This is what we have to accept. What are you talking about?
I'm saying in other way around, my lord. My lord, kindly see the procuring authorities, my lord, those who are in the bid evaluation committee, they could not have known that these bids have been only to file, my lord, to get it rejected, so that to show to the public that there are 10 bidders
From
participated.
where? And these persons whose bid has been rejected, they have not come forward and say
I understand, my lord.
that has been done. You are not an eligible candidate. You please satisfy us that the conditions are so harsh, so onerous that it really deprives you from participating, though you are otherwise eligible to participate. There is an act of malafide, there is an act of arbitrariness, there is an act of say nepotism or a favoritism or anything of that kind which can be shown, because the series of judgments of the high Supreme Courts are there, that in the contractual field, the limited scope under Article 226 is highlighted.
My lord, I have quoted, my lord, Jagdish Mandal, I have quoted in the writ petition.
Yes.
What your lordship can go into, my lord. I understand that your lordship is absolutely correct. My lord, kindly just come to page 215.
Now, after 213, 215, yes.
Yes, my lord. My lord, kindly see, those two have been declared eligible.
Yes.
Name of the bidder, National Bid Extra Enterprise, name of the bidder, Common Agency. My lord, kindly see
where remarks? I find
Yes,
not
remarks, my
qualified,
lord,
not qualified, not qualified. Everybody is not qualified.
My lord, these are the two national, these are the items, my lord. The columns are item numbers of the bid.
So there are two.
Those-
The one bidder is National Enterprises, another is
Yes,
a
my lord.
common agency.
Common
And the
agency.
remarks is not qualified, not qualified,
Not
not
qualified, my lord, in respect of particular items out of 147.
Sir, if
And
they are not qualified,
Madam.
qualified, then they are not qualified.
So they have been declared as L1. At the threshold, my lord, they could have been rejected on the ground of rejection, reasons of rejection.
Sir, this is within the wisdom of the committee, is within the wisdom that where they found that on these grounds, page 216, these are the items where they have been qualified.
Madam.
There is a difficulty. That's their decision to take it.
So, my lord, when the bid is submitted, my lord, along with the bid document of that entire bunch of papers, my lord, they have to file that. Otherwise, my lord, they could have, at the threshold, their applications could have been rejected.
Sir,
On these grounds.
this is in relation to a veterinary medicines. Somebody manufactures a particular special class of the medicine. Somebody manufactures the other class of the medicines. Nobody can claim that I will manufacture each and every class of the veterinary medicines. Nobody can claim. Now they have said that these are the items, the medicines. He is found to be qualified, having an expertise or having resources to meet the requirements. Then in that event, if they have allowed it, why the process should go as a whole?
My lord, only one thing, my lord. This is, my lord, they are not manufacturers, they are suppliers, my lord.
Sir, is there any restrictions in the tender document that only the manufacturers of the medicine will apply? It does not.
Everybody has to apply.
So if anybody who meets the other eligibility criteria, if they are permitted, where is the difficulty?
The difficulty is, my lord, we have been raising this
And
issue.
sir, you do not meet the requirements. You do not meet the eligibility criteria. How long you can go? The person whose bid was declared disqualified, they can come forward and say that this qualification, the ground is absolutely whimsical, arbitrary, not in consonance with the document.
That is why, my lord, this honorable court in its order dated 3/6/2025 called out, my lord, the issue regarding this incorporation of the conditions.
Sorry,
Page 116.
which matter? Which matter?
No, this is WPC number 15395 of 2025.
Is it appearing in the list?
No, this is, my lord, this is based on that order, my lord, we have filed our claim before the opposite party number 1. That was rejected.
What was the order?
Order, my lord, kindly come to page 116.
116?
116, my lord.
Nothing. It's not page.
Page 116, my lord, annexure 7. This was the writ application, my lord, where I was a party and it was disposed of, granting liberty to raise all these issues before the court, before the government, my lord.
Sorry, sir. The matter is still pending.
No, it is disposed of, my lord. It is
No,
disposed of.
page 117 does not say.
No, page.
Where is the order finally disposing of the matter?
That is next annexure, my lord, page 118.
Yes.
No decision is
Based on this, my lord, liberty was given to us by page relevant portion, my lord, page 120.
Whether the grievance petition has been redressed?
Yes.
That is the included order here, my lord, annexure 10.
Correct. Now tell me that now what is your, forget about it. Now this was a condition that you wanted to raise certain issues. And in the usual manner, the grievance petition was directed to be considered. And simultaneously, interim order was also passed for finalization. We do not intend to make any comment on that. Now, ultimately, the grievance petition is finalized. Now, tell me what is the wrong in the decision of the authority. Tell me.
Well, our grievance before the government was.
It has no bearing now. Tell us what is the grievance.
Well, grievance, my lord, incorporation of 3 years of experience with 5 crores of rupees, my lord.
Correct. This was already decided. This is already decided in Meher Agency's Nuapada, and it is also decided in Winners Pharma, Cuttack.
No, Winners Pharma is the present petition, my lord. I approached this honorable court, my lord, at the threshold immediately after the tender was floated.
Yes.
Thereafter, my lord, I was permitted to participate in the pre-bid proceeding.
Yes.
Pre-bid proceeding, I have raised my objection. That having not been considered, my lord, I have filed the present application, which was disposed of.
The same ground was taken that they cannot put a condition of the average turnover since last 3 years to be more than 5 crores.
Well,
it was rejected. Now, can you reopen the issue now? Tell me.
My lord,
It's your matter. I didn't know. Thanks to you that you said that this Nuapada is your matter.
No, that Meher, my lord, was not with us. Winners Pharma, my lord, was Michael.
He is your matter. Yes.
And I have clarified, my lord. And if you also look at the judgment there, my lord, there was no decision whether the legality and otherwise of the tender conditions have been considered.
Sir, then I have to go by explanation 4 to section 11 of the Code of Civil Procedure. Please read that. If that was an issue which was raised in the said writ petition, and if the said writ petition is decided, there may not be any reflection, then why not explanation 4 will come?
I don't dispute with the lordship's proposition, my lord. Kindly see, my lord. My lord, kindly see, my lord. One family has been dealing with the entire scenario.
This was your contention in the earlier writ petition as well. You have been raising and flagging all those issues all the time. And if one way or other the court has decided, you cannot go on reopening the same issue in subsequent litigations.
No, it's a changed circumstances, my lord.
No changed circumstances, sir. They have been participating all throughout. The writ petition is here, earlier writ petition.
Well, here is a judgment of this Honorable Court 2022, where it has been stayed. After it is dismissed by government, went to the Supreme Court. After dismissal of the, well, this is the order by one of the condition challenge. Well,
What condition challenge?
That supplier cannot be only manufacturer can be.
Oh, that is a different issue. He is not.
After 3 years, well, kind of.
Oh, he is not raising that.
3 years of stay. And
Whatever.
this Honorable Court and state went to Supreme Court.
We are concerned with the fixation of a particular criteria, the financial criteria, and this has already been decided by a coordinate bench. Why will take a dissenting view?
That is 2022, no tender. So they are saying from financial year 5 financial year.
Madam, the court is asking them why you are.
No, sorry.
You are really diverting the issue.
No, madam. I am.
Let us find out that what are the grounds of challenge. First ground is that they cannot fix a financial criteria.
Because there is no.
Second ground, tell me.
Well, people also can come to the grounds, my lord. I have paraphrased para 12 of my writ application. Kindly come to para 10.
10.
Para 12, my lord, as page 10 of the writ application. The estimated value of the goods to be purchased by has not been indicated in the disclosed by in the tender document.
Achha.
Violative of 212 of OGFR.
Yes.
Then, my lord, determination of EMD amount 80 lakhs was not disclosed to tender document.
Then
There was no tender floated during the year 2021 to 23-24.
So they are debarred from floating the tender in future.
No, then they have to incorporate the conditions, my lord, accordingly. Because
Whatever.
when one party is
Sir, it is not that this state only purchases the veterinary medicines. I think the country, our country is the conglomeration or the union of the states. That's why we call it a republic.
Well,
so a person is not really dependent upon one state. They have pan-India existence. They can go and compete anywhere.
well, here, my lord, Pan India
Anyhow,
have represented
whatever.
and their bids have been
Anyhow,
cancelled.
during the financial year, next.
Next, my lord, there is no tender float. And my lord, during the year 23-24, work order was issued in favor of both the agencies as an interim arrangement for more than 26 crores without approval of the finance department as per mandate of OGFR.
That has gone. The 23-24 chapter is over. Then next.
But that has got a cascading effect, my lord, for making them eligible because of the tender condition.
Anyhow, then.
My lord. Then, my lord, clause 5.2.8. Bidders who have 3 years experience, annual overage 4.50 crores or more in the
That was also challenged. That was also challenged in one of the matter, and mayor agency is gone.
No, mayor agency, my lord.
Not mayor. Sorry, winner. It is gone. Then.
My lord, those issues.
Winner Pharma is already a coordinate-based decision directly on this point. Now, what more?
My lord, if lordship, with great respect.
You are a winner Pharma. You are a winner Pharma.
My lord, kindly see the judgment. There was no discussion about the grounds taken.
Sorry, I do not think. 5.2.8 was challenged, being contrary to Rule 212I of the OGFR. Everything has been considered.
So far that OGFR, because we have been wrecking that issue of OGFR, my lord.
Suppressed in the present.
Oh, it has not disclosed.
No.
Oh.
My lord,
not disclosed that you have filed the earlier writ petition challenging the clause 5.2.8.
My lord.
Did you not refer?
Here, my lord, because those 2 writ applications, my lord, against those veterinary equipment, my lord, are pending. I have given the numbers, my lord. My associate is there, my lord. Your lordship
Sir,
will call for
I am asking you very simple question. I find that there was a writ petition filed by you being WP 1110 of 2025, which is finally disposed of on 16th of January 2025. Did you disclose this? Because I find from paragraphs that you challenge the same clauses.
My lord. But in a different tender, my lord. In a different tender. This is medicine, my lord. That was
the condition is one and the same. If same condition is imposed, and in the earlier litigation it has been decided that it does not offend the core fabric, can you re-agitate as it is a replica in every future tender?
Your lordship is absolutely correct. I don't dispute that, my lord. But in those tenders, my lord, where it was rejected, I filed fresh writ applications. Interim orders are passed.
I do not know. You are beneficiary of those. I wanted to know those matters so that I can
those matters, my lord, I have indicated in para 20 of my writ applications.
But you have not. Why you have not disclosed this particular writ petition?
No, it was not there, my lord. It was
not there with you, and you have filed this writ petition in the
24/7,
23rd July, and you do not, and you forgot what you happened in January.
No, but I have indicated.
I think memory is not that short that it will fade within a span of 6 months.
No, those 2 writ applications, my lord, which are pending out of that tender.
I am again asking. You are avoiding an answer. Have you pleaded anywhere? Had you pleaded anywhere that you also filed challenging those grounds, WP 1110? I am asking you a very simple question.
In the present writ petition, it was not there.
Is not there. So why not? I would construe a suppression of the material fact because it has a bearing. Clause
bearing in mind-
5.2.8 was also challenged there. Same clause.
My lord, in para 20, my lord, I have highlighted those two writ applications which are pending. Notices have been issued and matter is directed to be taken up on
Because you are a
24/6.
beneficiary, that's why you highlighted where that went against you, you have suppressed it.
No, in that writ application, if you also call for those two writ applications, I have highlighted at what stage that was filed and what was the consideration, what was the order passed.
Sir, don't try. I am asking you a very simple question. Have you pleaded where it went wrong with you?
No, I have not indicated
Yes,
about that particular writ application.
Then whether this one is not a material fact because your writ petition was dismissed,
Madam.
is it not?
Well, ought to have been disclosed.
Then why not we should say that it is a gross suppression of the material fact?
No, because my lord, if I would not have indicated my lord 9175 and 9231 of 2025 in para 20 of the writ application, my lord. Lords may call for those two writ applications, my lord, you will still find that I have indicated. Since it was a medicine tender, that's why, my lord, I have not indicated. I don't dispute, your lordship is absolutely correct. I should have indicated. Your lordship may call for those two writ applications, my lord. To see, my lord, whether I have suppressed that.
Sir, we are concerned with this litigation, which is before us. We are concerned whether there is a suppression of fact or not. And it appears from you also that you have not disclosed this very vital fact, that you challenge those conditions which was incorporated in the earlier tender, which is absolutely a replica of the earlier one in this tender, and having lost, could not succeed. The court says there is no arbitrariness in that. How can a coordinate bench take a decision that it is arbitrary in nature? So this is a material fact.
No, that your lordship is absolutely correct. I ought to have indicated that. But since the present writ application, the two writ applications are pending, where I have already
We'll
indicated
consider that also when the occasion would come, but this writ petition, we are not.
Only one aspect.
Sorry.
Can you come to pay annexure 20?
The counsel appearing for the petitioner vociferously
As
Don't hijack
If you want to
the rights of the other peoples who are waiting for their matter. Let it be called. Yes, call the next. 14.
48 million same tenant. Well, 48
Item
same
number?
tenant.
Yes.
48 is the same tender. Same tender.
it can be disposed of, my lord. It's no, I am not praying for any interim.
There is an interim order.
No,
I am not
48
praying for interim order, madam. 48.
Is your matter.
Yes.
Yes, that is, I can establish that from my records and they have filed counter, reply to rejoinder, everything they have admitted.
So there is no interim order. Then I have already said that if there is no interim order, you can proceed. Why you are harping on 48? Either you withdraw, no difficulty.
Good case, my lord. I am not.
So let us apply our mind when it is called on. Don't worry.
There is a interim order pertaining to the same tender. We have filed a miscase for vacation. The same tender.
How can be same tender?
Why in a high court? Why in a high court a miscase concept has arisen? Never. It's an IA within the main matter. Registration of a miscase.
40 you will pass the matter. Because
No, there is an interim order. We'll consider.
It can be hard. There is an interim order. And my lord,
Just wait.
in my
Yes, call the next matter. Let us see.
Case for dismissal.
We will.
48 may be place item. It will be disposed of.
Wait, madam. Is 9.
Item
There is one
19.
matter.
Item 19.
Who is appearing for the petitioner? Call.
Item number 14.
Therefore, municipality quoted a tender for rejuvenation of a big tank covering over 150 acres. The conditions will also kindly see the conditions were specific. Also kindly page 25. Page 25. I'm challenging the eligibility criteria of opposite partner of 4. This is not technically qualified to participate in the tender. This does not satisfy the tender condition. Page 25.
Yes.
It is estimated cost of rejuvenation of Jagannath Sagar, Kapur municipality. Periods 2. The bidding organization must have minimum 3 years of experiment in water body, desilting project and must possess convert C86 silt pusher. Because I'm saying that the opposite partner of 4 doesn't have both the requirements. Because the first of all is the experiment in water body desilting project, and second convert C86 silt pusher. Well, page 31 will also can you say, because after the bid was opened, I came to know about the documents. Therefore, I got it mailed. Also can you see page 31, the documents which the opposite partner of 4 filed towards experience mailed. That is page 31 to 37. That is basically road construction. All the certificates it is submitted related to road constructions. So let's can you see page 31. It is second column. Improvements such as widening and strengthening of Procedural road from
Give me a file.
Next page is also the same. 31. When there are also you see
Because that is missing.
then 30.
31, sir. Sir, page 31.
The page 31.
31.
31.
Engineering chief for OWSSP.
The office of super engineer.
Water.
Office of super engineer. That is my there. Office of Superintendent Engineer, calamity, the certificate issued by officer, sorry, submitted by officer of 4.
Column number?
Column number 2. Scope of work, name and location of the name of work. Improvement with widening and the strengthening of Beira Road. From
Where? Page 30?
31.
Page 31 of the
This is
request.
construction, testing, commissioning, and trial run of
I'm so sorry, but I'm so sorry.
structure.
I'm so sorry, my lord. I'm so sorry.
It was not coming to me,
It
that's
is,
why
I'm so sorry,
I took a
madam.
file.
It is,
I think I have to minimize it.
31, my lord, 31. Yes, I'm sorry.
I have to
I'm so
minimize
sorry, my lord. I was
it.
looking at page 37. Well,
Anyhow.
page 31, my lord. It is conservation, testing, improvement, trial run of seepage, of facilities, paragraph in town, is related to.
But that is issued by Odisha Water Supply and
That's issued by water supply, but that is not related to desilting. Well, the condition is that it has to be desilting experience. Page 25, my lord.
No, he should have the silt pusher that
experience.
That experience has to be there. He must possess.
Yeah.
Not experience. He must possess that particular.
Yes, experiment.
I think
Years of experiment.
one kind of a. This is kind of a.
This is
the
the desilting and other the cleaning of the pond,
like a excavator or something like
Excavator.
that. This kind of a thing is required. The use.
That they say that Convert C86 is the specific instrument.
And they say that at least if you do not own it, then at least the lease for 3 years.
That part I'll come later, my lord. I'm prepared to the 3 years of experience in water body, desilting project and development. That is the requirement, minimum requirement. I'll come to the Denver, Convert C86, my lord, because I have got a point also there. My lord, Taylor, so kindly see this plus.
So this is kind of a equipment which they require.
Equipment requires Convert C86.
Yes.
Silt pusher. So this first one, it doesn't have. The next page also will see related to construction only.
Page makes it condition mandatory.
Condition mandatory.
Page 20.
The condition mandatory. The two conditions are mandatory. The other conditions are not concerned. The conditions, my lord. These two conditions are mandatory.
Do they have this Converse C86?
No, my lord. That also they don't have. That also they don't have.
Where do I get it?
Conver is a yes, my lord.
Where do I get it?
My lord, Conver is a Dutch company, Dutch manufacturer, and but I have got out from the official website, my lord, and it has got only one authorized agent in India, the Dutch company. My lord, your lordship, kindly see what document he has filed. He has filed. Because I have got out from the brought from the official website that it has got only one agent with whom I have I have the agreement and I have taken the instrument on lease because that's very costly. That costs around more than 7-8 crores.
Opposite part number 4.
Opposite part number 4. That costs around 7-8 crores, my lord. Let's kindly see the page 73, my lord. Page 73,
yes.
That was
official website of the Convert.
74 you have enclosed.
No. Show us the document. Show us the document that he does not have.
Hello.
From where I will get it.
My lord, page 74 or so.
74.
74.
Yes.
Tax invoice in favor
He
of
said
part number 4.
it is sheet composing Convert C86 he has written, but that cannot be moth marketing because moth marketing is not the authorized agent. The authorized agent is only one company that is in technical services. And
suppose somebody has taken on lease or hired from a company, say Conver, and he wanted to create a sublease. If he wanted to create a sublease,
he claims to purchase it. He claims to purchase it.
So
he claims to purchase it for the cost of 10 lakhs rupees. He claims to purchase it. the official website ballot, it's a Dutch company. Dutch company has got only one representative in India, that is Matprop Technical Services, and I have taken lease from that company only. I've taken the lease of that instrument from that company.
Where is your document?
Sorry, my lord.
Where is your document?
My lord, page 73.
No, 73 is not yours.
Lease is page 59. Page 59. And it's a 5. Because it's a Conver is a brand of name of the company. It is not a machine. It is G86 is the model. And I have filed all the documents. That is the reason I was technically qualified. I have filed all the documents wherein I have got experience in desilting, experience and in desilting work 3 years. Rejuvenation of the work.
Yes.
And that this also have categorically objected to the authority, my lord, the representation at page 76. And also represented the authority when I came to know that he is being selected, that I immediately objected to it. And there is no reply to that. They have not given any reply. Page 76 or and studied. As specifically stated, all these facts are brought to the notice of the authority, my lord. So it cannot be like this, because when the specific the authority wants a particular type of machinery, a particular type of experience. If the one doesn't have, then he cannot.
No, what experience? They have the experiences. Only thing is that you.
No, madam, they do not have. The only road construction, madam. They have got the only road construction.
So far as the silt pushers are concerned.
No, that is my documents. That I have.
No, silt pushers are concerned. Your grievance is that though he has shown that he has purchased that particular equipment, but the person from whom he purchased is not an authorized person. Who will? It's a company who will take care of that.
But that is not also the machine, because the machine costs around.
No, here says that silt pushing machine, Conver C86.
That he has said so.
So
that he has said so, but that is not.
There is a possibility that this marketing private limited might have purchased from the Conver or any agent, and he wanted to resell. The make is also given. Can't he sell?
When I have brought it to the notice of the authorities is silent on this. When I brought it to the authority of the notice that notice of the authorities that you cannot do it because it is not the.
Then you serve the notice on the private respondent number 4. That's all.
No, I have not. I am not saying that your lordship may fast intimate right now, my lord. But I don't. I am conscious of that. But lordship may say notice by special messenger so that it can be
special messenger. You give it. Where is he? Located?
Jaipur, Jaipur.
So how the special messenger will be done?
Kalahandi.
Kalahandi is far off.
Yes.
So how? Special messenger cannot go there. 10 hours journey. Can't go there. Give a notice. You have the email address?
We'll procure it. We'll procure it from the authority. We'll procure it from the authority. We can send it by mail also.
Send it by all means. Issue notices. And in addition to the same, the petitioner is also directed to serve
May I please your option. Lordship, in this matter, the petitioner is challenging the tender condition in option. Similar matter is posted to 18 option.
Transport price
Yes.
variation.
Usually item number 8.
Price variation.
This is similar matter is posted to 18.
You come on 18, come ready with the matter. Yes.
Item 16.
2-3 matters.
3 matters.
3 matters.
Yesterday
Already.
is posted to 18.
Yes, that is there.
Let's
16.
Well, it's item number 16. May I be permitted to appear on VC minutes?
Yes.
Let's in this matter, well, it's the present petitioner is aggrieved by the selection of opposite party number.
Have you, Mr. Marana?
Mileage.
On private, Mr. Gokulam has
Not been so.
Mileage, to be.
There is a caveat.
Yes,
Mileage, to be.
Private petition.
You have had cabinet.
So caveat is there. Why you did not serve the copy?
Malats, to be fair, Malats, I have been trying to reach out to my learned senior in the morning since the morning. Malats, there's the phone call issue. Malats, I will not raise that issue before your lordships. I'll serve it. I'll serve it today. The extra copies.
Your counterpart is here.
Yes, Malats, we are serving.
Have the copy. Come on Friday.
Malats.
Yes.
Malats.
Item 17.
And please, man. Item 17. If copy numbers 1, 2, and 3 are here, they are clearly served copy of the petition yesterday. And we catching up on Monday to that. Yesterday night, we have been served with the copy of the petition. The tender.
But at least he is entitled to at least 48 hours. Come on Monday.
We are also serving an additional affidavit. It's basically, it has a document where against us. So I don't think some point.
Let them serve on.
You are
serving it right.
Copy number 1, 2, and 3.
1, 2, 3.
I'll find the Baklat Nama. You want to
Ashok Parida is also there. Just
give him a copy here and now.
Right away.
Then order to.
Let us come. We will show what is there.
MCL is the primary party. Now price bids have been disclosed. So if they award, there would be an issue for us.
Let us see.
That's our government of India. Other two are
government agencies. The government marketplace. Central government.
Let us.
Yes.
Item 18.
Others, no? May it please your lordships. My lord, I'm appearing in item 18. This is a case of a surrender of a mine. I bid for the mines and I'm now intending to surrender. I have given a notice of, my lord, a list of dates is being handed over to your lordships. If your lordships will kindly have the list of dates, I'll just point out 4 or 5 dates. On serial number 3, 2824, I issued a notice to R1 for intention to surrender under Rule 21(1) of the Mineral Concession Rules 2016, 6 months prior to the date of surrender. That's the rule. I've issued notice on 2824. Then I submitted the final mine closure plan and serial number 4, 9/10/24, the mine closure plan was approved by the IBM under Rule 24(2). So the mine closure plan has been approved, point 1. Then on 14/10/24, I made a formal application for surrender after the FMCP was approved. Then a copy of the approval of the FMCP was also enclosed, and I made it clear that on 30/11/24, I will stop the operations. On 30/11/24, I actually stopped the operations. Then I intimated to the R1, the state, and the IBM that I have stopped on 30/11/24. Further, my lord, on 7/2/25, this is point number 2, no dues certificate was issued by R2, the Director of Mines. The highest authority in the mining department is the Director of Mines. He is issued the no dues certificate. So I have the plan approved. I've actually stopped the operations and I got a no dues certificate. Then I have to do R&R, rehabilitation and reclamation, which I started doing. And then 7/4/24, serial number 10, the Regional Controller of Mines, IBM, issued a certificate under Rule 21 for certifying that reclamation and rehabilitation work in accordance with the approved FMCP had been carried out. This is point 3. I have done the R&R also. Then on 10/4/24, I submitted to R1, the state, compliance under Rule 21(2)A and 2B, which are the only rules applicable, and evidence to support the implementation of the approved FMP, the no due certificate. And I said, I have completed all that I have to do under 21(2) and 21(2)A and 21(2B. Then, my lord, on 10/6/24, this is where the grievance starts. R2, who issued a no due certificate, asked for a renewal of a bank guarantee for 55 crore for the next 5 years, 25 to 30. I've stopped the mining operation on 30/11. I got a no due certificate from him, and I've got the FMCP approved, implemented, and certified. Then I reply, then kindly see 7/7/24, this letter is not issued to me. It is issued by R1 to R2, stating petitioner's application for surrender may not be considered due to non-fulfillment of 21(12)(2)A. Now kindly see the rule, Malad. The rule is shall approve. Kindly see Rule 21(2) of the Mineral Concession Rules of 2016. Mineral concession, minerals other than etc. Rules 2016. It's chapter 7. Your junior is there. Now kindly see Rule 21. My lords, have the rule. Surrender of the mining lease. The lessee may make an application for surrender of the entire or part of the mining lease after giving a notice in writing of not less than 6 calendar months from the intended date of surrender.
Which one you are reading?
Rule 21, my lord, of the 2016.
21. Okay.
It starts by saying surrender of the mining lease. The lessee may make
this is not. I think the wrong book has come.
My lord, it is that is the small one, then big one, and yellow.
The mineral concessions.
Okay, hydrocarbon. The other than atomic and hydrocarbon energy.
That's 2016.
Yes.
Maybe page 4.
Surrender of the mining lease.
We have a wrong one.
That's not the rules.
Yes.
The lessee may make an application for surrender of the entire or a part of the area of the mining lease after giving a notice in writing of not less than 6 calendar months from the intended date of surrender. Such application shall be accompanied. All that I have done. Now, proviso does not apply. 2, the state government shall allow the surrender. Shall allow surrender of a mining lease under Subrule 1 if the following conditions are satisfied. A, the lessee has submitted documents to evidence implementation of the approved final mine closure plan. IBM is issued a certificate. B, all dues with respect to the mining lease have been settled. R2, Director of Mines has issued the certificate. So A and B have been complied with long ago. Then, in case of surrender of the entire area, the performance security shall be forfeited. I'm not concerned. The state government may refuse to accept such surrender of the entire or part of the area for reasons to be communicated in writing to the lessee. So if they want to reject, notwithstanding 21(2), they must give reasons. Now, my lord, if your lordships will kindly go back to the list of dates. We are at serial number 12. After FMCP has been approved by the IBM, after no due certificate has been issued by R2, the very same R2 issues a notice saying you give a performance guarantee. Then I reply, then on 7/7/25, R1 to R2, stating that the petitioner's application for surrender may not be considered due to non-fulfillment. Crucially, this letter does not take cognizance of petitioner's compliance letter dated 10/4. Copy of this letter was not furnished to the petitioner, was furnished only on 21/7. That coming 8/7/24. This is the second demand. Letter from R25, letter from R4 to provide month-wise production and dispatch figures of minerals for the 5th year from 27/6/24 to 26/6/25. Then 14/7, R2 rejected petitioner's reply dated 13/6 and directed the petitioner to furnish the reassessed performance security. Then I reply to R4's letter providing production and dispatch figures till 30/11 I've furnished on 15/7, till the date of cessation of mining operations. 21/7, petitioner was marked a copy of the letter from R2 to R4, whereby R2 requested R4 to ensure compliance of 21(2)A and 21(2)B, relying on R1's letter dated 7/7. I reply on 28/7, petitioner to R2 bringing attention to the compliance letter dated 10/4 and the communication dated 21/7 had been issued without reference to the petitioner's compliance letter. Now, 2/8/25, R4 again writes to the petitioner to provide month-wise production and dispatch figures of minerals for the entire 5th year. I said I have already done up to 30/11. I've stopped the operation. Now, my lord, the 3 demands, one for a bank guarantee, one for providing dispatch figures after 30/11, and one a reassessment performance security, are all completely without jurisdiction. 21(2)A has been complied with by the IBM certifying I have completed the FMCP, and 21(2)B has been complied with by the R2 himself issuing a no due certificate. That's why, my lord, I'm afraid they will demand the bank guarantee. They will demand the performance, the figures for a dispatch, which I never did after 30/11, and take coercive steps. I am requesting that this entire proceedings be stayed until they are able to answer why 21(2)A, because they have not given any reasons. Assuming that the 7/7/25 letter at serial number 14 may not be considered, which is sent to me on 21/7, serial number 18. Assuming that that is a rejection letter, it has no reasons. Assuming it is not a rejection letter, then when my application for surrender is pending, how do they issue a demand for performance bank guarantee, performance reassessment, performance security, and production figures for the period where I've not even worked the mine. It's all without jurisdiction, without application of mine, and no reasons have been given in the letter of 7/7/25. Those are my submissions, my lord. And until they file a short answer, has the 21(2)(a) and 21(2)(b) have been complied with? The answer is yes. Then it shall accept the surrender.
Yes.
Made two objections, very serious objections. Number one, I think there is an element of fraud.
What?
I'm coming. It's really serious. There is a use of pending dues. I do not know how this officer has issued. There is a pending writ petition bearing number WPC. Your Lordship, may I just furnishing. This is just the instruction which I received just now. I had called for the officers. The petition was filed day before. It has been listed before 48 hours. WPC 28232 of 2021, which is filed by the present petitioner, challenging a demand of 696 crores. This has not been disclosed in the present petition. It's a suppression. I'll come to that. Number two, Mira, I've already discussed with the Mines Additional Chief Secretary to take immediate action against the Deputy Director who has issued this fraudulent certificate as required under 21(2)(b). So it's a serious thing. I'll come to that, answer it. Your Lordship may keep it to tomorrow. I'll come back with the concrete facts because just now I have to take a written instruction on this. It's a very serious matter, Milord. An attempt has been made to place fraud on the exchequer. Milord, we are taking very stringent action against the hiring officials. Very serious, Milord. I'll come back
Sure, the demand has been stayed.
Let it come tomorrow. Let us not see, this writ petition may also be called. This has not been disclosed. This is
Can I disabuse the Milord, just give me
let it come along with the other petition.
30 seconds. Give it to me. Just give it to me. WP, Milord, just give me 30 seconds. WP 28382 of 2021. There was a demand. The demand has been stayed by your Lordship's court. So where is the question of my paying it?
It is
28382, if I heard it right, the learned Advocate General, 28382 of 2021.
I'll come to that. So,
but it's been stayed. Why should I? That has nothing to do with the surrender. That's nothing to do with the surrender.
I'll answer that. I'll answer tomorrow. Let it come tomorrow.
Come tomorrow.
Yes.
Let us see.
Very well, madam. Very well.
Just now I received the instruction. Let it come tomorrow. I'll reply.
Item number 20.
What about 19 is over? Yes.
Order dated 5th October 2023 has been violated, my lord.
Which one? 20.
I will take your lordship to page 9. Page 9.
Yes.
Paragraph 7. As an interim measure, it is directed that since the construction of work of Kalyan Mandap was stated above has already been started at Gopalpur village, no further construction will be started in the newly decided location at Gediapalli village till the disposal of the recovery.
So what happened?
Started process of construction of Kalyan Mandap at Gopalpur village by subtracting the land and
So now they have started at the another village. What is this? Gediapalli. No, what is
10 and 11 I have annexed that signboard.
7.
We have started a process for construction of Kalyan Mandap at Gediapalli.
But they were not. They were constructing in Gopalpur. So observation was no construction is Gidiapalli.
Construction is started with total.
Now, what is this? I can't read.
But as in, I'm reading paragraph 7, right?
No, you are taking me to page 10 and 11.
But 10 and 11 are English translation. I have not given my lord of.
So my lord can read, so I should be deprived of reading what is there. No, it's all right. I understand.
I will give translated talk.
Gram is Gidiapalli. The work description is given.
What is this?
This is Gram is Gidiapalli.
Okay.
This name of the work is Gidiapalli Kalyan Mandap construction. The project is fifth state finance commission. This one, the cost of 10 lakhs. And 24-25 was the year. So
And this is
it
what
has
a
to
laying
be-
of
it has to
laying
be-
of the stone.
It has to be constructed in Gidiapalli. For that money was sanctioned.
Okay.
So it is-
And now he says that it should be only constructed in Gopalpur, not Gidiapalli.
That is the subject matter of the REIT application. But the order dated 5th October.
No
is
construction. Then why the construction is undertaken?
I have to file one affidavit matter because your lordship kindly see order.
No, you file, but please consider.
I understand.
There is already an order. There shall not be any construction at Gidiapalli.
I understand your lordship.
Then how this initiative is taken?
Correct, madam. Your lordship is correct. For a moment, your lordship kindly see order in 2025. There in that order, another REIT application has been referred to. Another REIT application has been filed. Some order is passed there. That is why I'm.
Page?
Sorry?
Which one? Page 19?
No. He has not given these documents. I got the instruction right now.
Yes.
That in this case, on 19th February 2025, an order has been passed. There, in that order, another REIT petition, that is 713 of 2023, has been referred to. The order passed in that REIT petition. So I pray your lordship to grant me
What is you take the time, but what is the
I understood.
the orders passed there? Was there any restrained order above the order of the division bench?
Conflicting situation.
How can it be? And who was what is the constitution of the bench to pass that order?
Another division has done. Final Justice Sinha as acting Chief Justice.
What is that number? What is that number?
Case number is 10. In the REIT
You are
petition.
referring to which case number?
Number WPC number 30212
In the
of
same
2023.
where you passed the order. The writ petition is here.
Yes, REIT petition is there.
The,
That is why I was
wait,
saying.
don't
Your lordship kindly refer to 19
don't
February 2025.
What is 19 February?
Yes, my lord. Your lordship kindly see this.
Just. No, there was no order permitting you to do that.
Will I express properly. Confusion came to my mind because your lordship kindly see the second paragraph.
Correct.
Mr. Martin and the advocate appears on behalf of
Just 1 minute. Yes.
interveners and demonstrate from disclosures in his client's application by order of 5th May 2022, a division bench has disposed of his client's writ petition.
Yes.
On being informed that the Kalyan Mandap would now be constructed at Radiavali village.
Yes.
So this creates a confusion because your lordship directed.
So where is
Go
this
ahead with that.
WPC number 713 of
That is why
23?
I am saying. Your
Where
lordship
is this? This
It has to be dealt with to file the disposing
Can
the
you-
writ application. This has not
713.
nothing to do with now at this stage. They have already
713
violated the
of
order,
23.
this honorable court.
23.
That order they have obtained by suppression of facts. That will be dealt with while discussing while disposing of the original writ application. That has nothing to do with this stay order. They have already violated the stay order. Those things they can discuss.
Sir, mere violation does not mean that they are in contempt. There should be a willful and deliberate violation. And this is if there are conflicting orders and certain orders were passed subsequent thereto.
Not
then if they are, what is this? This order.
Was filed previously.
So
Before filing of
whatever is the order.
And I have also stated therein that this order has been obtained by suppressing material facts. Those will be decided at the time of disposing the original writ application.
Something different, that is single bench.
Single bench.
I think that is not the number.
That is.
Erroneously.
That's 22. They were
22.
Dina Bandhu.
I have got.
That has
What?
I think the printer.
What is this?
That year is wrongly written. It's 22.
That matter has already been.
What is the? It's Mr. Das, nothing comes out from there. There was no permission, nothing of that kind.
I did
Simply
say-
recording of what has been stated in the IA is a recording, and then the court says that since the original cause of action is no longer there, so just dismiss the writ petition. So there is neither a permission nor any kind of a sanction which is not.
There is the permission. After going through this order, a confusion came to my mind. That is why I said your lordship might be some day.
What confusion? Tell me, let me have the confusion clear. Can there be any possibility of a confusion? Let us see.
Someone filed an intervention petition.
Please look at the order. When the order is totally quoted, then we have to look at the order. What this order says.
19
5th May, you said that this order can create a confusion.
No, I don't. I didn't. My intention was not that.
Then?
My intention was that the third line has
Yes.
disposed of the client petition on being informed by an intervener that land mandap would now be constructed in the Gadiapan.
Correct.
This information was given to the honorable court. Based on that information, some order has been passed.
Nothing order. No order is passed.
Thereafter.
Look at it. No order is passed. Simply it records that Mr. Mohanty, the learned advocate, appears on behalf of the applicant interveners and demonstrate from the disclosure of his client's application. The order dated 5th May 2022, a division bench has disposed of his client's writ petition on being informed that Kalyan Mandap would now be constructed at Gidiapalli. Paragraph 1 of the said order is quoted. It does not really simply record it. He points out subsequently the project was approved by the government on 10th April 2023. Then Mr. Das, I think you appeared Yes, you appeared.
Possibly I must have appeared.
Yes, I was just looking at your name, B. Das.
B. Das.
That means you might be there, presumed. He appears on the state. We have documents before us to show the administration has initially proposed and issued work order for construction at Gopalpur. Said order dated does not give illumination as to why the administration changed its decision. Petitioners want construction of Kalyan Mandap at Gopalpur. Mr. Das submits the construction began and then stopped. Mr. Mohanty submits it was because of interference by this court. State will file the affidavit, nothing.
Yes, sir.
So,
Your Lordship.
so it remains that nothing is decided. And if the court's order of 23 says no construction at Gediapalli, how can an authority start construction at Gediapalli?
That has been stopped. That's what my submission was, which has been recorded. Mr. Das.
Gopalpur.
Sorry, madam.
Gopalpur stopped.
Construction began and then stopped.
That is Gopalpur.
My lord.
Please read. It's a Gopalpur.
Yes, correct.
Gopalpur.
You are speaking.
That is what?
Paragraph 8 of your counter.
Sorry, ma'am.
Paragraph 8 of your counter.
Some other I don't know. Counter which means
Paragraph 8 of
No. In a contempt, you are entitled. There is no difficulty explanation. Now he has filed a counter.
In that it.
It's a counter.
No, in a contempt.
No, contempt is.
Contempt has not filed any affidavit.
This is the first time.
First time.
So they have a right. They are entitled to file their opposition. Yes. Issue notice on the arrest contemners. Should we record that you waive the notice or something? What?
Well, second.
Let notice.
In a contempt, actually, the notice has to go.
One contempt.
Huh?
One contempt.
Yes. Returnable after 2 weeks. That notice has to go, otherwise you can't appear. He is an individual, you are not a state.
He is not a state. Correct.
After 2 weeks.
Item 21.
Execution appeal. Official liquidator was a party to the execution proceeding matter. Inadvertently, he has not been added as a party in the present appeal. So I have already prepared an application to include him as a party and I have sent it to the officers to send for
waiting. For waiting.
For waiting. I pray my as well also.
This is submitted by the additional government advocate that an application. Since they want to put the record right, he is to be brought on record.
Yes. But what I heard, my lord, subject to my friend's confirmation, the official liquidator appears on Thursdays only in the High Court. Because of his other official this thing, so any date subject to your lordship's convenience on a Thursday.
Thursday.
So that he can.
Next Thursday, not fortnight. Within a week, next Thursday.
Item 22.
Okay.
No, 14. Item number 23. Dispose of your on
Oh, DMT.
My lord, I appear for the opposite parties. Mr. Acharya and Mr. Agarwal are assisting me. My lord, this now stands covered by your lordship's judgment.
I can change my view.
Definitely, my lord. Obviously. Obviously. I was not party to that.
So my brother may not agree.
Yes. My lord, Mr. Justice Raman was a party to that Kai matter bench. That was a writ petition without. No, that was. They are relegated it. It is totally.
Yes.
In terms of.
This example.
It should be
Same. It is identical and this one.
Identical.
Yes, disposed of.
Grateful, my lord. Grateful.
5 matters will same.
There are 5 matters, my lord. Grateful. I take your lordship's kind.
You are appearing in all the 5 matters?
Yes, my lord.
I think beneficial.
Beneficial, my lord. Along with you? But along with me, Mr. Acharya, I have my junior, Mr. Avro Mujumdar here.
Yes.
Grateful, your lordship. Grateful.
Item number 23.
Hey, please, my lord. My lord, last order number 3, my lord. Directed me to deposit further 10%. I have already complied the same, my lord, on 27 July 9.
Further.
Yes, my lord, further.
Constitution of Tribunal. Awaiting Constitution of Tribunal.
Actually, my prayer was that I have not paid that 2.5% that amenity scheme for condonation of a delay for.
So we imposed more onerous condition of 10%. Now they are.
Let it be tagged with those matters.
Yes. Pursuant to the order dated 23/7/2025,
Next page, your lordship. And Lord, last time, my lord, item number 24. Yes. Last occasion, my lord, your lordship may please just have a look at Annex 9, which is just corrigendum to the order in the original. My lord, friend from the revenue had also pointed it out. I have got it yesterday, my lord, but I have not been able to find it in the counter. It is there. I am forwarding it to your lordship. It may be taken on record. And I am also serving a copy with my learned friends.
What?
Your lordship, this is a matter of service tax. He has challenged
Yes,
the order in original. So in Annex 9, he has not attached this order in order. Now today is attaching this order in order.
Yes. My lord, you are not.
He should have filed an order in original also. That's the last time we have objected to that.
But it should,
It should
have been last time also.
it should have been by virtue of one affidavit.
Copy of order.
Absolutely. That's why I'm saying it cannot be done.
My lord, identical matters are pending before this honorable court
Make
in
a
WPC number
one line of affidavit, one page of affidavit.
This may be tagged with that case, the facts are same, law is involved in it.
Mr.
And number of repeats have been annexed.
Kindly appreciate that it is a corrigendum order you have enclosed and challenged it. So corrigendum order forms part of that original order. Unless that is brought on record and incorporated in the petition, it will be difficult. That our view is you should just make it straight, file it by way of an affidavit so that it can be taken on record and dealt with in the appropriate manner. So file it.
Has he understood?
I filed it with memo in the counter. Which affidavit?
Give one page affidavit, sir. One page is sufficient so that we will take on record. It will be a part of the annexure.
Yes.
Tell him he has not understood.
I'll
let him explain it.
Item 25.
Hello, item 25 pertains to section 743 and the subject of all three sub items.
Yes.
I already filed my affidavit memo in item 1 and also if you are opted to appreciate, I think number 27 and 29 is also 73-4.
Let it. Other side is here.
27.
27 and 28.
27 and 29 minutes.
27. All 26.
Item 26. 26.
The petitioner before my lords is a educational charitable trust. The objectives are outlined at page 17 of the brief. I am here before my lords. I had filed my audit report in 10B as mandated under section 12A(b) of the Income Tax Act. There was a mere delay of 28 days for which I had filed a condemnation of delay application. I am here before my lords against the mechanical.
We have dealt with.
Yeah, and we don't have.
Condone the delay.
28 days.
Covered matter, but lots of don't have a copy with us.
Judgment is delivered by this court, condoning the delay.
No, I know. So what? 28 days. Serve a copy.
Nothing serving copy is right now.
And don't.
Tomorrow.
Dekhiye.
Check up whether that judgment applies.
Yes, 28 days within the country.
I've enclosed a circular also.
Yes. Tomorrow.
We have dealt with that circular in that judgment.
I'll be serving that just.
Check out.
Yes.
28.
So good.
So, challenging the GST as cancellation or justice matter.
Cancellation. Yes. Yes.
Item number 30.
May I please, Your Lordships?
That is there. There are three matters to do. First matter.
Yes.
Now, first matter is mine, my lord. My sole grievance, my lord, against the order of the Honorable Single Judge is that, my lord, whatever I have argued, whatever document I have submitted, whatever submission I have made has never been reflected or considered. That is the sole grievance.
Then you can approach the same judge. You invite his attention that I have submitted many things, but you should.
No, I could have filed, my lord, because the number of applications have been filed. Number of writ applications were disposed of by that common judgment, my lord. That's why, my lord, number of writ applications have also been filed. And all of them have been listed today, my lord. Earlier it was listed, the caveat was there, we have served copies, my lord. Honorable Single Judge, my lord, has in fact paraphrased, rightly paraphrased, my lord, the facts in page 30, my lord. It's a case, my lord, determination of interest seniority between two groups of direct recruits of different years.
One who has come by way of promotion and one who have come from a direct.
Special drive.
No, special drive. One is direct recruitment, one is special drive.
Post of 811 and another 137. The people who belong to that 137 category, they got entry into the cadre and appointment.
No, that is what I'm saying, that there are two cases. One is that certain posts which are filled up by way of promotion and certain posts by way of direct recruitment. Is it?
Another
two sources of filling up the post. Now inter se seniority is to be determined.
Madam.
Why direct recruitments? But it says that 7 categories, the dispute is seniority amongst two batch of the direct recruitments.
So the one batch is that special drive, which is not in accordance with rules.
What is special drive?
Let to first Mr. Tripathi is arguing, therefore let it proceed. I am in the fourth matter.
I am in the second matter.
You are in a?
He's opposing us.
Oh, in all the matters.
Yes.
Just one thing.
In all the 10 matters, opposing.
Yes.
We are the petitioners before the single bench.
So you peoples have been divided, but she is one.
No, we're not divided. We are also there, man.
We're not there.
Divided in submissions.
Can I
Mr. Tripathi is only one slender argument is his contentions were not taken care of.
His argument is that he has raised several contentions. Those have not been taken care in the judgment. That is his argument. That's why I say you are divided in your submissions, but she is firm on her submissions. One.
Yes.
Can I interrupt?
May I suggest one thing?
Who are you, sir?
I am for the promoting. Your Lordship, just before some time, Your Lordship was referring to that there is also involvement of interest seniority fixation.
But in this matter does not concern them.
Your Lordship, yes, my Lord. The entire issue is There are two batch of direct recruits who are fighting amongst them and promoting. The gradation list which was questioned, there, my lord, the promotees who ought to have been placed above both the direct recruit batch, my lord, they have been downgraded by one batch, by both the direct recruits batch. So that is the problem for which we have also filed writ petitions before this honorable court, and those writ petitions were also analogously had and disposed of by this common judgment. Where the honorable
appellants, we must So these appeals are also pending.
Yes, my lord.
So you are a beneficiary of this order. So you are really a category of the respondent.
Yes, I am
respondent. So let us hear. One appellant has very candidly said, I have no other points except that my contentions have not been considered and recorded. I think that is his contention. So he closes. Let us go to another. Right to begin under Order 18, Rule 1 lies with them.
Put that question whether promote.
No, need not have to.
That is.
Who will? Now, Mr. Tripathi, you are over.
His
submissions. Yes.
My submissions and the documents I have filed, vital document I have filed, it was also placed. Because
no, I understand. Yeah, I understand. Yes. Then we would definitely see the judgment on from the, I would say, the broader angle of the perversity. If you can satisfy it's a perverse order, having not considered a very material piece of an evidence, or have come to a finding without any material before it, I can definitely consider this as a perversity.
Well, if you also look at Annexure 2, page 94, because my submission will be very short, Annexure 2, page 94.
Yes.
It's a clarificatory memorandum filed in course of hearing.
Yes.
This is a matter, I have enforced, because one of the contention before the honorable single judge was that our seniority is required to be changed because our appointment was against backlog vacancy.
What?
So to show that there was no vacancy.
No, what vacancy?
Backlog vacancy. They have said
backlog vacancy. The voice is so distorted, sometimes I can't.
I think, my lord, on the next day, my lord, I can go to the court, my lord, because this week, my lord, I am destined to go to court. That's why, my lord, I am not going.
No, let the others argue. How long they will argue? No, you complete. Backlog vacancies, I got it. Clarification memorandum, yes.
In the memorandum, my lord, I have enclosed to the letter of the government, Home Department, dated 18/6/2020, annex page 98, my lord.
Yes.
It's a report, page 98.
Yes.
It's a report of the government showing that there was no backlog vacancy by the time the recruitment was made.
Yes.
If this document would have been seen, the grievance raised by Ms. Rotha's client would not have got the benefit. Because our appointment was made, in respect of advertisement number 8 of 2012-13, and their appointment was made in terms of advertisement number 6 of 2015-16. But because there was an administrative delay in our appointment, they say because we have got appointment at the earlier point of time, we should be taken serious. That was their grievance.
Okay. So you are really contesting some of the appellants as well?
Yes, sir.
He's appellant in one case.
Some of the appellants means the other appellants of the...
Yes, sir. Yes.
So he is really opposing some of the appellants who have also filed the separate appeal.
No, I don't think.
No, he says that...
same footing. There are 4 appeals, if I correctly understood. One appeal has been filed by Mr. Tripathi.
10 appeals.
it is divided into two parts, 7 one side, 3 other side.
I could follow your theories.
If you look at the impugned judgment, the very first paragraph. If you look at the impugned judgment, first paragraph, I think learned judge has divided it into 2 components.
Yes, sir.
7 and 3.
Yes.
Groups. Not groups.
No, so I am coming on the first category.
10. 7, 3. Yes.
That is what I said.
Right.
Yes.
Please concern Mr. Manthus. Induction. Yes.
Direct.
I should not.
Oh, his induction.
No, 7, Mr.
So your recruitment process was initiated prior to their recruitment process.
No.
Mr. Tripathi?
Well, our recruitment process, well, kindly see paragraph 2, well,
What?
of the judgment.
Yes.
The first, I'm belonging to first category, well.
Within 7 or 10?
7.
Within 7.
Yes. Yes.
But my remark was that whatever I have or that was never taken note of. Not even my appearance also noted. Well, there are, if you also look at para 2.
Yes.
2 advertisement to fill up the post of ASOs, that is Manor Assistant Section Officer, were issued in the year 2012-13 and in the year 2015-16. Advertisement number 8, dated 6/12/2012, was issued by the Orissa Public Service Commission, inviting applications to fill up 811 vacancies for the post of ASO through direct recruitment. Since some dispute arose relating to number of reserve posts leading to filing of judicial proceeding, a corrigenda was issued on 21/8/2014, modifying category-wise vacancies and extending the last date of application with stipulation that candidates who had already applied are not required to apply. Subsequently, 14/5/2015, advertisement number 6 of 2015-16 was issued by the OPSC to conduct a recruitment for drive of ST category. That is, we are saying special category candidates, and 140 vacancies in total, and all the posts are reserved for scheduled type category candidates only. The recruitment process pursuant to advertisement number 8 dated 6/10/2012 could not be completed due to some unavoidable reasons, including file of judicial proceedings, and in the meantime, recruitment process in respect of advertisement number 6 dated 14/5/2014 was completed with recommendation of 139 candidates by OPSC on 22/12/2015. Among the recommendees, 136 candidates were issued with the appointment order by the Home Department order dated 26/1/2016. Subsequently, 10/9/2016, the OPSC sent the list of 810 selected candidates in respect of vacancies of advertisement number 8 of 2012-13. Among these recommendees, 787 candidates were issued with the appointment order on 5/10/2016 by the Home Department order number so and so. Now, whatever they have while preparing the gradation list, department has rightly indicated our appointment. That is pursuant to advertisement number 12, advertisement number 8 of 2012. Above the appointees, pursuant to made pursuant to
advertisement number 8 was in respect of 2012 vacancies, 12-13 vacancies.
My lord.
Correct. And this was in relation to 800 and something post.
810, madam.
Yes. And so far as 2015-16 is concerned, the recruitment process was also complete, but their appointment letter was issued earlier.
Yes. Yes.
Yes.
And your appointment letter was issued later.
Yes.
Yes. Letter. That's a factual aspect, but we cannot issue that. That's a factual aspect.
The one legal
But
aspect.
since both are
one legal aspect. What is to be done? One has to ascertain that when a person is born in the cadre.
My lord. My lord, that issue, my lord, is now, my lord, pending before the larger bench. That mega general judgment has been referred to in Hariyaran case, my lord, to the larger bench. And in Hariyaran case, my lord, mega general judgment was doubted. the presidential value of that judgment has been doubted. Even my lord, a coordinate bench of this honorable court also doubted that and said that whatever that has been done, what has been reserved, what has been accepted by Parmar, that is to follow till a decision is taken by the larger bench. But the honorable single judge here, my lord, said that whatever your lordships have said, appointment made early to be born in cadre early, that same, my lord, they will be taken senior. But here, my lord, the case is slightly different because they are both are direct recruits.
Both of them?
The rule is silent, my lord.
Okay,
Both of them are direct recruits, my lord.
correct.
Since both are direct recruits and one is silent as to how my lord interested dispute is to be made between two direct recruitees
So what to be done?
of different years.
Oh, correct. So that's why the question
since-
arose, then who is born in what cadre? And how that birth can be recognized?
No, yes, but that is the issue rightly to be decided. But my lord, the honorable single judge has said, if you also look at the operative portion,
Let me then go through the judgment first.
my lord.
May I interrupt? If you also will permit, at least so that the factual aspect, unless it is clear, then the question of law of the judgment, applicability of the judgment. If my Mr. Tripathi will allow.
I have not read the brief. I have not gone through it. I must be, but what I could imagine or perceive, what perceive is that there is the recruitment drive initiated for the posts which were vacant as on 2012-2013. There is another recruitment drive which was undertaken for the vacancies which are there in 2015 or 2016 or 2014 or 15, whatever. 15, 16 or 14? 15, 16. These. It appears that in a very contemporaneous period of time, the recruitment process for both were initiated.
There were to clarify certain facts.
No, I'm telling you, in a contemporaneous period of time, I just said, when I said means there was a gap of 6 months or a 1 month or 1 year, but in a contemporaneous period, you can say it was started. And it was going on. It appears that parallelly it went on. The result was declared. The result was declared. Both the results were declared, but the appointment order were not issued. It appears that the recommendation in respect of a latter, the vacancy of the latter period was sent first.
That is correct.
Sent first. The appointment letter were issued. Then for the vacancy of the previous year or the earlier year was sent letter. The appointment letters were issued. Now, after getting the appointment letter, everybody joined. The vacancy which was there at the latter point of time, the persons have joined earlier. And the vacancy which really falls due in the earlier point of time, these candidates joined. Now, the question is that when a cadre is born, a employee is born into the cadre when? It is, the question is that it is, that's the question. The question is whether this seniority has to be counted from the date of an appointment or a joining to the post, or the seniority is to count it in respect of a cadre which was available on the day.
Melody is correct. Absolutely.
This is what I understood.
Let us clarify. Let us place in
this case.
So the only it's a question of law which is to be decided that what will happen.
Yes. That's the point. That is exactly
a person who was not born in a cadre of 2011 and 12. Now,
Yes.
it's a tentative. Who was not born will be senior to a person who was born in a cadre of 2012-13.
That is the answer.
So.
Actually, we clarify. Please, I mean, Arambha, we are not.
It's a pure question of law. No other facts are required.
Only the rules I will show, my lord.
It's a proposition of law.
Yes, we will show the position of law only.
Yes.
I'll place from the rule first. Thereafter, we'll go to the judgment law. And my lord will see the judgment of the income judgment before discernible.
That's what clarification.
Point of vacancy is concerned.
We'll clarify, my lord. We can also clarify. Not that.
On the point of vacancy is concerned, it's there in the judgment also. After looking at all the documents, the court has found that even from the point of vacancy, there was no difference between both the recruitment. And there was a gap of 9 months.
You are again talking law. I am on a very basic factual metrics, on a very factual aspect. This facts which emerge, I think, is undisputed in this.
Yes.
You can't say that there was a recruitment process initiated to fill up the vacancies which arose during the year 2012 and 13. Can you say?
Yes. Yes.
What? It never arose.
Yeah, that's what I wanted to
I am again saying there was no vacancy when a recruitment notice was issued. Have they not indicated that to fill up the vacancies for the year 2012 and 13?
Yes.
Have they not?
Yes.
It's the 811 vacancies.
10.
Yeah, 811 vacancies which were initially advertised, went through a court case on the ground.
Whatever be the reason, I am just talking about the vacancy.
Also, second recruitment.
That was 2015-16.
Vacancies were at the same time. That is what I wanted to show.
No.
Yes, Your Lordships. May I show?
Is the crop.
No, you can't argue contrary to what has been recorded in the judgment.
Your Lordship, that's exactly.
You have accepted it says, I read only one paragraph.
Your Lordship.
I read only one paragraph. No, I wanted to read paragraph 2.
Show.
I just say to deal with the first category, the fact described succinctly are 2 advertisements to fill up the post of ASO was issued in the year 2012-13 and the year 2015-16. Advertisement number 8, dated 6/10/2012, was issued by the OPSC inviting application to fill up 111 vacancies for the post of ASO through direct recruitment.
Yes.
Since some dispute arose regarding the number of the reserve posts relating to filling up, a corrigendum was issued on 21/8/2014, modifying the category-wise vacancies and extending the last date of an application for stipulation that the candidate required to reapply. Subsequently, on 14/5, advertisement number 6 of 2015-16 was issued to conduct a recruitment drive for ST category candidate for 140 vacancies in total, and all the posts were reserved for scheduled tribe candidates only.
Yes.
Now, question is again whether these were 2 notified different vacancies or it is a vacancy of the same year.
Same year. That's
Twice it has been notified. One for scheduled reserve category and one for open category.
800 vacancies which were advertised. There was an allegation that it exceeds a 50% reservation criteria. There was a court case. Then OPSC, what it did, it removed those extra SCBC and ST posts, added some general posts to it, and made another advertisement of the same 800 posts. And those extra 137, which they removed, were advertised in another advertisement, which is the second advertisement. And both of them then started proceeding together. For the point of view of vacancies existence, both existed at the same time. That's a finding also which is there. And then the recruitment started. These 137 posts, which was part of the second recruitment advertisement, there the examination happened first, the selection happened first, the selection list also happened.
Though the advertisement happened later.
Yes, your lordships. And both of the advertisements were stalled because of this dispute that, what we should do with this extra posts and change this. All was stalled, your lordships. There was only one requisition, single requisition then went for both the advertisement.
How can there be a separate one examination for a schedule reserve category candidates and one for a general category candidates? It should be a one. If it is the vacancy of a particular year, then in that event there will be a one examination. If it is a two examination, then it will be considered as a separate vacancies.
Your lordships, two different examination happened. It's a fact. And two different selection lists also happened. It's a fact. The second advertisement, all its recruitment and all processes were running 9 months ahead of this first recruitment. And we came into the cadre on January 2016. They came into the
You belong to the reserve caste.
Yes.
Reserve category.
After, your lordships, 9 months. But there is no special recruitment. Your lordship, special recruitment has a meaning under the ORV Act. Special recruitment is generally.
I'm really surprised to note this, that how can there be a separate examination, separate notification for filling up the vacancies in one organization?
Because
that general, can it be? I do not know. There will be a common test, and then the evaluation is made on that basis, and the separate panel of the successful candidates can be prepared. That this is what the panel of this ST category. This will be an SC category. This will be ex-serviceman category. This is the general category. Everything is
out of this 811 post, my lord. These 17 ST were there and not that. Separate. I want to be
only thing is we have to find whether this vacancy was there in 2012.
No,
more than I'm just asking. Can it be said that if 811 plus 137, there were vacancies of more than 900 something?
Issues which
I'm asking. Can there be a more than 900 vacancies during that?
Allow us to start.
I understood. Take your seat. Now let us see. Let us see from the fact. Take your seat.
Because the point, my lord, now that should be answered first. Thereafter, I'll go in the process. I want to proceed, my lord. My lord, have a glance to page for as the second writ petition. I am sorry, the second writ appeal 1040. I am there. The second one. Then the document.
You just show us.
Yes, sir. Therefrom I will show it. Kindly see, my lord. The advertisement is page 45. That is our advertisement.
What it says.
8 of 1213.
Yes, that was the first
one. Wherefrom we have been recruited. My lord, kindly see the vacancy position.
Yes.
What, my lord,
that is what I really wanted.
Only kindly see, my lord, the page 45.
Yes.
Out of these 811, 11 posts are available in the Odisha Governor Secretariat Service.
Okay.
And second one is Odisha Secretariat Service.
Correct.
Out of these 11 in the governor's office, my lord, there are UR1, SCBC 3, ST 5, well, can take note of ST, and SC 2. So this is 11. So for others in the Odisha Secretariat is concerned, where we belong, Odisha Secretariat, UR is 190, SCBC 216, ST 317, SC 77. This is called 800. This was the vacancy position advertised. That means, my lord,
that was in 2012.
13.
Vacancy number 8.
8.
Yes.
So now, my lord, it is page 60, sorry, page 55, annexed 2, where from they got it. The advertise.
The vacancy, the notice number 6. Advertisement number 6 of 2014.
15, 16. The vacancy is, my lord, the special recruitment for 140. That means 3 in Governor Secretariat and plus 137 State Secretariat. The total 140 ST vacancies was advertised in 15, 16. These are separate vacancies. And moreover, if at this juncture, I will take my lords to the rule itself. What the rule says. The vacancy has to be notified. And then only.
Does it say in that this vacancy of which year?
Yes, madam. That is their rule. Oh, sorry, but in the advertisement.
Yes. 140.
140, they says, my lord. They never speaks about what they say. I'm just reading out, man.
Please.
Application. I'm just
online application form will be available till so and so. Applications are invited online through the proforma application to be made available on website from 25/15 to 26/15 for special recruitment to 143 Governor Secretariat, 137 State Secretariat post of Assistant Section Officer in Group B of the Odisha Governor Secretariat Service and Odisha Secretariat Service under Home Department in the scale of so and so, getting the grade pay so and so with usual dearness and other allowances as may be sanctioned by the government from time to time. The posts are permanent. Vacancy position as requisition from the Home Department, the vacancy position are given below. So this is the
when Home Department gave?
Home Department, when it has been given, my lord, that is not on record. When it is given. But rule says, my lord, if at this juncture I will take my lord's rule.
Sir, I'm just factually
Yes,
trying to find out something.
In the advertisement, my lord, this advertisement number says when they have to receive the requisition, but this is a letter requisition.
But
only
they did not have they indicated the vacancy position as of date, as on date, or the vacancy position is silent.
Silent. If we will read it with the rules, my lord, prevailing on that date, it can be confirmed.
No, I understand that every year anticipated vacancy of the first, these are the very uniform rules everywhere.
Yes, sir. That is
yes.
That is why I want to
by 31st December of a year, both the actual and the anticipated vacancies.
My lord, kindly see the rules. The rules governing the field at the relevant time. There are two rules will be taken to my lord. So, my lord, two rules.
Why two rules?
The first rule was the Odisha Secretariat Service Method of Recruitment and Condition of Service of Assistant Section Officers Rule 2010. Actually, my lord, Odisha
Don't understand. 2012-13 drive was there, and then the another act has subsequently came in the meantime.
To 2016, this rule was further amended, and the rule was subsequent rule came in 2017. Actual gazette was in 2017. Notification in 2016. That rule is called Odisha Secretariat Service Method of Recruitment and Condition of Service Rules 2016.
16. When it came into force?
16, my lord.
When it is notified in the Gazette?
11th January 2017.
11 January 2017. And the recruitment process was initiated prior thereto.
By that time, my lord, the recruitment process and joining, everything is over. By the new rule. For the seniority list.
Before the new rule.
Old rule. Under the old rule.
So read under the old
under
rule.
the old rule. My lord, only online, I'm holding the rules.
Yes.
My lord, the recruitment process was under the old rule, but when the gradation list or the interest dispute was decided, the new rule came into existence by that time. So therefore, the government has proceeded accordingly as per the new rule. There is a discount to place all these rules. Can you see, my lord? This rule starts with Annex 5 plus 164. I have given it. Gadget. But the new rule says the basic things were method of recruitment, I would say, because this is a direct recruitment. Now I'm placing it, I'm not comfortable because as my lord have stated 3 persons. The 7 plus 3, my lord have stated. 3 is my lord just trying to clarify. These first disputes are the direct recruit, we are the 8 of 12, 13, we belongs to that category. And my learned friends clients, some of the clients are from 6 of 15, 16. The direct recruit vis-a-vis direct recruit. This is the one dispute. Other dispute, my lord, there are some induction. There are 3 methods of recruitment in this process. I will read it to my lord. There is an induction. Because the group, from the group C, cadre, some person are also eligible.
By way of promotion. Let's say.
Yes. And there is also a direct examination. Through this induction, there are 2 methods. So group D employees, they also can sit in a written examination. 5% of the quota can be filled up by them. By a recruitment process.
By virtue of a jump promotion. It's an incentives given.
Yes, that is group B.
Yes.
That is the point. With this background, my lord, I will just say, my lord, the rule, here will be disputed, my lord. The recruitment year has not been defined. But now, my lord, from after reading out the entire rule, I will show, my lord, recruitment has been, though not specifically defined, but it will have a meaning from the rule itself. That is up to my lord to decide, but I will say it may not be correct. But that is the year has been defined in the year means, my lord, it says year means calendar year. Because there all the disputes, my lord, revolve around this word. So it must be keep in mind. So now I am starting with rule 5, method of recruitment. Method of recruitment. Subject to other provisions made in these rules, recruitment to the cadre shall be made by following methods, namely A. By means of competitive examination to be held once in a year. I am giving a process once in a year by the commission. Commission here is the Odisha State Public Service Commission. B. By induction from among senior grade typists, senior grade diarist, recorder, and senior data.
These are the feeder posts.
These are the other posts.
Feeder posts.
Feeder posts. And third category is induction from Group D, as I stated, Group D employees working in departments of government by way of a limited departmental acquisition. These are the three categories. But what is 5A says, my lord, there shall be one
every year, one examination every year.
Not more than one.
Correct. One examination every year.
Every year. So in the new rule, 2016.
So what is the language which is used? There shall be
There shall be, I am reading it once again. By means of comfort, subject to other provision made in this rule, recruitment to the cadre shall be made by following methods, namely A. By means of a competitive examination to be held once in a year by the commission. This is the wording. So now we are getting. So, but in the 2016 rule, if I say comparatively, this has been said at least once in a year. The word my lord will change in that 16 rule, which is coming 2017. There say at least 1 year, this particular provision.
So there is a word at least prefix once.
Yes, it is only mandated. My just
so it is
one.
Yes.
But in 16 rule, there may be more than one, at least once. So now my lord kindly see. Rule reservation. Rule 6. Notwithstanding anything contained in this rule, reservation of posts or vacancies, as the case may be, for scheduled caste, scheduled tribes shall be made in accordance with the provision of the Odisha Reservation of Vacancies in Post and Services for Scheduled Caste and Scheduled Tribe Act 1975 and the rules made thereunder, or any other law or rule in force in the relevant time. B. SCDC, women, sports, and ex-service and physical handicapped person shall be made in accordance with the provisions made under such act, rules, orders, or instructions issued in this behalf by the government from time to time. I'll pause here, madam. What happened in Odisha, madam? This is an advertisement in 1213. In 2008, madam, so far this SCBC, Social Educational Backward Class is concerned, State of Odisha brought in an act, SCBC Act, Reservation Act for the social backward, keeping 27% of the total vacancies of an advertisement reserved for this category. So that is why, my lord, that the obstruction start, why this recruitment process could not proceed further. This particular advertisement was challenged by some of the persons, those who are objecting that 27%, by challenging that act itself in the tribunal. In that is one Amar Chatoi's case, that has also been taken note of by the learned civil judge. So that case continued for a longer time, and 2014 that was filed. That was taken longer, sorry, 12 it was filed. It was that SCBC Act was set aside. That is why the process was halted. And when it was set aside, the matter come to this Honorable Court. The order of the Honorable Tribunal was upheld by this division bench of this Honorable Court. And this 27% was thereafter government has taken decision. 27% will be reduced to 11.25% for these SCBC banners. That is the reason for which we the people, the advertisement of the year 2012-13, this process could not proceed. And in the meantime, only to cater their need, madam. In this advertisement, as I have told to my lord in the advertisement itself, 8 of 12-15, 371 posts was also available for the ST candidates. And there was a stipulation with regard to the age. In 2012-13, if my lord, I will take at this juncture to the advertisement, my lord will find the age limit for that particular advertisement. What my learned friend was saying, that it is from that post, which is not correct. Factually, it is not correct. Now, can you see what is the age limit prescribed in that advertisement? Age is advertisement I'm reading out, madam, is 47. A candidate shall under 32 years and above 21 years of age as on 1st January 2012. And he must not have been born earlier than 2nd January 1980 and not later than 1st January 1991. This is a stipulation for the G1. The upper age limit is relaxed by 5 years for the candidates belong to the category of.
That is because of the Central Act.
Reservation. So this
because of the Central Act.
So beyond this is there. But so far, advertisement 6 at this juncture, my lord will read. Can you see that advertisement? What is the age stipulation? Age, that is also in the advertisement. Page 56. Age limit.
Yeah, what
this
it
is
says?
6 of 15-16, my lord. This is the age limit.
Yes.
A candidate shall be under 32 years and 21 years of age on 1st January 2015. We are in 2012. So there is a gap of 3 years. And he must not have gone earlier to 2nd January 93 and not later than 1st January 94. Upper age limit relaxation by 5 years for the candidate belongs to the citizens also. So there is it cannot be said that it is the same year. If it is that it is the same year, my lord, as per rule 5A, there should be one advertisement. There cannot be two advertisements. And furthermore, if it is there should be uniformity in the age. Because some of the candidates here in 6 of 15-16 might not be eligible to apply even in the 12-13. The same is also the position for us. Some of the person now we are eligible by 12. We may be overaged by this date. So it is incorrect to say that there was one vacancy, one advertisement, and that necessarily 2 advertisements only to give them some benefit. The ST candidate, the second advertisement 6 of 12, 15-16 all for ST. When there are 317 posts are available along with us, they are competing with us, they have been selected also. All are there with us. So when those people are there, these people are ineligible to get an appointment. For 2 counts, my humble submission is first, this age limitation. Further, because there was one advertisement, 12 people, this was earlier advertisement. So latter advertisement was issued for the reason best known to the government, and it is a different year and a subsequent year. That is why, my lord, because our selection was dragged only because of that Amar Chhattoi's case challenging to that SCBC Act. That is why our post was reduced, and again, corrigendum was issued to our advertisement after that case was over. In that, I have given it annexure 1, 21/8/2014. This reservation was made, so the vacancies were reduced like this man. After the corrigendum, initially I have stated, my lord,
811.
811, the breakup was
something 300 something for SC and ST. I understood.
Everything was reduced.
How?
Now, my lord, this 16(4)(b) has been applied, constitutional mandate. Now, my lord, you are 400, SCBC 11.25, that they have stated so. This is 90, ST 22.5, they are 180.
So number of vacancies remain the same. That is 811, but it has been refurbished in accordance with the law, where the UR category post becomes more, and then the SC, ST, they are accordingly given.
Much obliged. That article 16(4).
So there is no variation so far as the total number of the vacancies are concerned.
Had it been so, well, then this 37, they could have claimed that yes, we are from one vacancy. So this is the position of law. Now, my lord, I will take out again to the rules. What is the how the competitive examination is going? Now, my lord, 7. I have read out reservation, rule 6, page 166. Direct recruitment. 7. Rule 7 says competitive examination. The competitive examination for direct recruitment to the cadre shall be conducted by the commission. 2. The Home Department shall communicate the total number of vacancies. That my lord was posing this question to me in the initial thing. The Home Department shall communicate the total number of vacancies. That is the existing vacancies, if any, and the anticipated vacancy likely to arise during the recruitment year. Here, my lord, I just posed that
calendar year.
If you read it in a whole, recruitment year will be substituted by calendar year. So if you go in that way, my lord, recruitment calendar year. Here the calendar year advertisement was in 12-13. So that is why the vacancy, whatever it is there, Home Department has to communicate to them. And 811 posts were communicated. So it cannot be said that 137 was there along with us. But that is the mistake in that. Now, my lord, vacancy likely to arise during the recruitment year to be filled up by the direct recruitment to the commission in the first week of December, indicating the post to be reserved for candidates belong to different reserved categories. So this is the answer to my lord past question. The commission shall, on receipt of the vacancies from the government in the Home Department, publish the advertisement at the latest by the last week of December in the Orissa Gazette and 2 widely circulated Oriya dailies, inviting application from the candidates eligible to appear at the examination. The date and place of the examination shall be decided and notified by the commission. The scheme subjects for the examination and the syllabus shall be specified in the schedule. These are the procedural manual. So now more important. Rule 8 is more important than others also. Eligibility condition. Again, my lord, the age factor is there, but in the rule itself. It says
It understood that eligibility criteria is.
that 32 and all these things was there inbuilt in the rule.
I understood.
My-
In first advertisement where you are a beneficiary, the age is given as on 1st of January 2012. He should be between 32 to 40. Correct?
Yes.
But in the subsequent advertisement number 6 of 2015, the age criteria is 1st January 2015 and the same 32 and 40.
Yes.
So according to you, when two different age barriers or criteria have been given, then it is inconceivable that they are these vacancies are of the same year.
One. Yes.
This is what you wanted to.
I
understood.
Yes, sir. Now, rule 8 only one line, that recruitment year, what is stated? Only 2 or rule 2. Age limit. A candidate must have attained the age of 21 years, must not have been age of 32 years on 1st day of January of the year of recruitment. Now, again, my lord, year of recruitment.
I understood, sir. I understood what you wanted to say. Just I wanted develop something more.
Yes, sir. Now,
show us.
My lord, can you see, my lord, how the list is to be prepared? How the merit list is to be prepared? That is rule 11. My lord, preparation of merit list. On the basis of the result of the examination, the commission shall prepare a common list of successful candidates found suitable for appointment in order of merit, subject to reservation of different categories, and forward the list to the government. The list shall be published by the commission for general information. The list so prepared under sub-rule 1 shall include the names of successful candidates and shall be equal to the number of vacancies notified by the commission. So 811 members, they have to send it. And this is the, as per their merit position. This is the position. Now, my lord, so far these other two groups, that promotion, that deals with 12 and 13, when I will argue the other points, my lord, I can take my lords to that. And there also one thing I will say with regard to the promotion, and the one line I will read it. Rule 12 says promotion of Group C employees. The 5B, there are two other categories. Group D, the Group D to
5% there and 10%.
This is 10% vacancies arising in a year. But again, the word in a year, subject to maximum 10 posts in the cadre of assistant section officer in the department, government shall be filled up by promotion, selection of senior grade typist, senior grade diarist, recorder, senior data entry operator of the department of government, provided they have rendered at least 10 years of continuous service, inclusive of at least 3 years service in the respective rank and possession of bachelor degree in any discipline with adequate knowledge, computer ability, so on. So in a year, that is, I want to give a passage. The same thing in Rule 14, procedure for selection by the Department of Examination. It says, procedure for selection by the committee. The committee shall meet at least once a year, preferably in the month of January. Prepare a list of employees suitable for promotion to the rank of assistant section officer, taking into account the existing vacancies, if any, and the anticipated vacancies of the year. That means up to 2012, whatever the vacancy is, that is to be considered, and their eligibility will be suitably counted accordingly, and they will be given promotion. And so for limited department of examination is this 15, Rule 15. Again, it says 5% of the total vacancies arising in a year to a maximum 5 posts. Other thing, my lord, limited department, other thing remain the same. So now Rule 16 says the select list. How this is to be done? The list prepared by the Commission under Rule 11 and the committee under Rule 14 and 15. Rule 11 is the common merit list of the directory, 14 and 15 is the promotions. Shall form a select list for appointment to the cadre in the service. The select list should ordinarily remain in force for a period of 1 year from the date of their approval by the government or until select list are prepared afresh, whichever is earlier. Then the interest seniority. Under that rule, Rule 17, which is now the dispute here.
Yes.
Rule 17, interest seniority. The interest seniority of the officers appointed to the service in a particular year shall be in the order in which their names appear in the select list. Those appointed by promotion / selection under clause B of Rule 5 shall en bloc be senior to those appointed by limited departmental examination under the clause C of the Rule 5, who shall be in turn en bloc be senior to those appointed direct recruitment under clause A of the rule. Like this one. If 1 year there are all these things happen.
I understand.
So this they would go up. We have the direct recruits. So all these persons, if they would have been there, they would have placed up. But here in this case, these promotees were also made after 12-13. That is in 13-14 and 15-16. These promotions were made later to us, not in the same year. So now actually dispute starts with the word year. It has been used. And the Honorable Single Judge has proceeded in the matter without looking into this various provision what I have stated to my lord. The rules. What the rule says. Court has proceeded as if calendar year. So if you are that Meghachandra's judgment is now they born into the cadre, so proceed in that way. But this rule has not taken into consideration. If I will be permitted here, my lord, at this juncture, the judgment is also taken note of a very important facts in para 39 of that particular judgment. If any rule governing the field, this judgment has no application. Meghachandra says, my lord, if sir, I will read out Meghachandra, my lord. Only one line.
Para 6-2. Meghachandra, which court?
Meghachandra, only Supreme Court, man.
Yes, what it says.
My lord, that is reported in 2025. SEC 689, I'm giving 2 copies. These are the judgments. Others also I have given. I have. Because prior to this, Meghachandra, my lord, NR Parmar was holding the field. My lord, only one. I will read out entire after some time. Para 39 may kindly be seen. Para 39. The applicability of this judgment, the Honorable Court has had. Now this also I sent to a larger bench in the case, subsequent case of Hariharan. And following that Hariharan, a coordinate bench, Honorable Single Judge, another single bench in a case of OFS officer, where I was also the counsel. There this says, since it is referred to larger bench, so no decision as per Meghachandra, it should wait. Whatever the gradation list is there, status quo is to be maintained. Another, that was also shown to the Honorable Single Judge, Honorable Single Judge has not accepted that. That is another Honorable Single Judge of this Honorable Court, my lord. In respect of the OFS of the finance service officers, but there also this point came. There the Honorable Single Judge has held, since this particular judgment has been referred to a larger bench by the Honorable Constitutional Bench by the Honorable Supreme Court, and no decision has yet been, and this has been held to be permissible by in the case of Hariharan. So whatever the position of the gradation list is there, seniority is there, it will continue. It will abide by the final decision by the Honorable Supreme Court. That was also placed before the Honorable Single Judge, this Honorable Court, but it was not accepted. Therefore, so now principle 39. The judgment in NR Parma relating to the central government employees cannot, in our opinion, automatically apply to the Manipur state police officers governed by the MPS rules 1965. We also feel that NR Parma had incorrectly distinguished the long-standing seniority.
Which one you are referring?
This para 39. The first judgment, Megachandra para 39.
Yes.
Para 39.
Yes. Yes, yes.
The judgment in NR Parma, towards me.
Yes.
The judgment in NR Parma relating to central government employees cannot, in our opinion, automatically apply to the Manipur state police officers governed by the MPS rule 1965.
Yes.
We also feel that NR Parma had incorrectly distinguished the long-standing seniority determination principle pronounced inter alia Jagdish Chandra Patnaik, Suraj Prakash Gupta, state of J&K, Pawan Pratap Singh, Ravin Singh. These three judgments and several others with like enunciation on the law for determination of seniority makes it evidently clear that under service jurisprudence, seniority cannot be claimed from a date when the incumbent is yet to be born in the cadre. In our considered opinion, the law on the issue is correctly declared in Jagdish Patnaik, and consequently we disapprove the norm as assessment in interest seniority suggested in NR Parma. Accordingly, the decision in NR Parma is overruled. However, it is made clear that this decision will not affect the interest seniority already based on NR Parma, this first, and the same is protected. This decision will apply prospectively.
Yes, prospective overruling. Anyhow,
That line is important. Then, except where seniority is to be fixed under the relevant rule from the date of vacancies, date of advertisement. My response to this last line, the two things my Lord Honorable Court has taken exception. If there is a rule and there is a vacancies, so this judgment, this born into the cadre criteria will not be considered. I am reading out once again for myself. This decision will apply prospectively except where seniority is to be.
If I say there, that it will apply. We are mutually destructive. If the addition list which has already been done is now being protected and this will not be affected by this judgment, then how in the second it says that from the date of the vacancy or from the date of the advertisement has to be done?
That one got the larger basement.
Suppose a vacancy may be prior to this particular judgment.
Yes.
Everything is done. That protection of the gradation list is already there, finalized.
In fact,
and then subsequently.
Constitutional bench in Malvar, Pindo, that judgment is not Supreme Court, that has not been taken note of by the Megachandra judgment.
That is why
we'll clarify. Please don't disturb. Please don't disturb. Please wait.
It's a point of
complete.
that judgment which your lordship is looking at is from state of Manipur. What happened is in state of Manipur,
I will consider. Don't worry. I'll consider it. In the state. No, nothing. Don't inculcate any kind of a misconception in the mind that the bench would be misled or confused. Don't worry.
So my response submission is
there may be a lot of interactions just in pursuit of understanding or to bring clarity. Don't. Yes.
So this particular paragraph, what I have understood.
Since I am online, we are online. I can't utter some other words.
So only I can submit, my lord. This judgment of this honorable Supreme Court.
But these two lines are really that has to be.
My lord, I'm fully agree, but we cannot also speak.
Exactly, that is the reason why.
But only I can say, my lord, it has been now referred to a larger way. That is why. That is why. The another single judge.
So it can be possible to harmonize both the sentences are that if on the basis of that particular gradation list, any seniority position has been given, or he has attained the promotion by way of seniority, being at the top, but after this refurbishment of the gradation list, if his position goes down, at least that is protected.
Here in this particular case, I can say only, my lord, in the meantime, the petition appellants here, they have got 2 more promotions. Now at the DEX officers. If this judgment will be implemented.
Yes, what you want to refer more?
Yes, sir. Now, my lord, kindly have a. Now, my lord, therefore, I have taken, my lord, from Rule 17, the interest seniority, how it is to be determined. By. That is why I have taken, my lord, to that judgment of my lord Justice, my lord on Supreme Court in that Megachandran judgment.
Except when senior.
The interest seniority, I am reading out the rule for 1 second for myself, my lord. Rule 17. The interest seniority of the officer's appointment to the service in a particular year shall be in the order in which their name appear in the select list. Appointment and promotion, this is something different. So my response submission is, since the select list from which we have been appointed relates back to an advertisement of advertisement 8 of 1213 and relates to the vacancies of that particular year. By that particular date, in 2012, the advertisement was issued. Whatever the vacancies were there, that was calculated by the administrative department, it comes down to 811. And basing on that, we have been selected. But because of this disruption, by challenging that 27% reservation from the SCBC, my lord, that is the admitted position here also, that the same advertisement was the challenge, this was dragged. But the fact remains, because these ST candidates, their advertisement was on 16, what I said, my lord, 6 of 15, 16. We could not have a quarrel over them if there will be a separate advertisement in a subsequent year. This entire thing in the interest seniority always refer to a particular year of recruitment. So year of recruitment as provided in Rule 7, it is called the recruitment year. And Rule 8.2 says that year of recruitment. If we'll read this 2010 rule as a whole, my lord, everything relates to the advertisement, the year of advertisement, and the recruitment process begin in that particular year. Only because of this.
But that is Megachandra has held, otherwise paragraph 46. Paragraph 46.
That Megachandra judgment only 39 says it has.
Paragraph 46 thereafter, this recruitment year you are talking about, what the Megachandra says.
Yes, fine. I'm just coming.
Come to paragraph 46.
Yes. Well, as earlier discussed, Rule 28 of the MPS Rule 1965 shows that seniority in the service shall be determined based on the date of appointment to the service. The particular Rule 28.1 of the MPS Rule 65, which is applicable to both promotees and direct recruits, provides that seniority shall be determined by the order in which the appointments are made into the service. If seniority under Rule 28 is to be determined based on the date of appointment, it cannot be said that for the purpose of Rule 28.3, the seniority direct recruits should determine on the basis of the date of initiation of the recruitment process. The term recruitment year does not and cannot mean the year in which recruitment process is initiated on the or the year in which vacancies arises. The contrary declaration in NR Parmar, in our considered opinion, is not a correct law. This is the judgment referring to the, because in the NR Parmar matter that I have also given. NR Parmar, by referring to that IT Income Tax Department circulars, the Honorable Court has held that if a process starts in a particular year, the seniority starts with them and the interest seniority will be decided accordingly. But so far this para 46 is concerned with reference to that Rule 28 of the MPS rule, that Manipur Police Service Rules by 1965, this finding was there. But what I want to submit before this Honorable Court, my lord, our rule says the clear the
No, it's every year, once in a year, everything what you are saying is there.
So this was not the parametric rule as that of the MPS rule. That is why we can take an exception to this para 46, with due respect, I would say, my lord, it has no application. So far our rule is concerned. Because in 39, para 39, the Honorable Court has held, if something is decided or something is to be under your own rule, then this judgment has no application. So that is why this 46 has no application, my responsibility. And now, my lord, kindly turn to what the Honorable, at this juncture, my lord, kindly have a glance to the next rule. The 2000, because what happened, the factually I am just submitting. This recruitment, the first batch, this advertisement of 6 of 15-16, their process was completed, but small number of candidates were there. Their process was complete on 5/1/16. Appointment notification was made in that paper, and they joined in sometime in February 2016. Our process was completed in October 2016 after the decision in that Amar Chatto's case. In October 16, we all have been appointed. October or November, sometime they have been appointed. The Honorable Single Judge has held that since that they have joined in January, now you are in October, so you are junior to them. But my submission is, when you see what they done, the gradation list for the interstate dispute was not decided on that particular date. This Megachandra judgment has come only in 19/11/19. 2019, madam. Till that, my lord, NR Parmar holds the field. NR Parmar was overruled by this judgment, madam. So NR Parmar says that the recruitment year. So that is why. But the process of the process of determination of seniority, if provisional gradation list was published on 18/4/18, that is after the new rule came into force. And when they came before earlier occasion, they came before this honorable. These are the facts on record. They came before this honorable court. And honorable court said, if file a representation, they will consider by the authority. And their representation was rejected by referring to 2016 rule, man. And that order has not, though challenged, it has not been set aside by the honorable signatures in the entire order. That was challenged by them, but that was not set aside. So the answer is obvious, my lord. That still, and now at this juncture, I'll kindly see the rule. What does it say? Interstate seniority, how it will fit in the new rule? Because by that, the date the interstate dispute was decided, the rule was there. So this rule, I'll not kindly on page 176, annexure 6, I have given. This rule, my lord, only whatever the rule I have shown, I will only show, my lord, one line. That what are the changes? My lord, rule 4. Method of recruitment. There, my lord, in 10 rule, it is rule 5. And rule 4 says, rule A, in respect of the post assistant section officer group B, as specified in clause 3, by means of competitive examination to be held at least once in a year by the commission in accordance with rule 6. That at least once in a year. There, my lord, it is once in a year. And further, direct recruitment, all these things, my lord, continues. Now, the interstate seniority is rule 17. Page 184. I'm just reading through. Interstate seniority. 1. The interstate seniority of the assistant section officers of the service in respect of a particular recruitment year shall be in the following manner, namely, the promoted officers shall be reckoned interstate in order on which their names appear in the select list. 2. Direct recruit officers shall be reckoned interstate in the order in which their names appear in the merit list prepared by the commission. The office 3, officers appointed by selection under subclause 2 of clause A of rule 4 shall en bloc be senior to those appointed by direct recruitment under subclause 1 of the clause A of rule 4. The interstate seniority of these officers in the grade other than the assistant section officer in the service shall be in order in which their names appear in the approved select list from under rule 16. So my response submission is the parameter provision of the select list is rule 11 in 2010 rule. So select here, if we leave apart these promotees, well, there is two group of persons before mine. One is a direct recruitment of the year 2012-13. Another is a direct recruitment, maybe ST 2015-16. Under this rule, only the rule says the interstate seniority assistant section officer service respect of a particular recruitment year shall be following manner. It says that if in a particular year their seniority will be decided. There is no prescription that how
I understand your entire gamut of argument is that one has to give emphasis to the word the recruitment year or a year.
Yes.
If the recruitment year is reasonably ascertained from the advertisement or the publications which have been made, and if one can also decipher therefrom that so far as the age criteria is concerned is different, then it cannot be said to be of a same year or a recruitment year. So this ruled out the possibility of the vacancies having arisen in the same year.
Right.
This is what you say.
Right. And
then the moment, if it is of a different year, then in that event, anybody may be appointed later on, but he is really born into the cadre when the vacancy arose. So he should also be placed above the position of the persons who have come in the vacancy arose in the latter area.
Obligement, much of that.
I understood that what you wanted, so all the endeavor is like that.
Yes, that's true.
So according to you, you wanted to say that this cannot be a criteria. The joining to the post is not a criteria to determine the seniority.
Fine.
You say that if in the same year, if there is a recruitment, then the order of precedence or order of preference is also given.
Yes.
That the normal promotees will go above
Right.
to the limited, the promotees from group C or a group D, and then the direct recruit would come at the bottom.
Yes.
So this is what you wanted to say.
Yes, sir.
What more?
Yes, one more. This recruitment year, though in the other statute it has not been decided, but the state of Odisha, so far the police order is concerned, they have defined recruitment year. Though in this not in year, recruitment year has been defined. Just now, my lord, I have it. I have also referred it. I have not the other file. It is there. I will show it, my lord, in the net.
It is not defined here.
My lord, the recruitment year, they say that recruitment, the advertisement, when the process starts, it is the recruitment year. They have defined. Now the Odisha government has defined. If you borrow that from that police order, because no other provision is there, my lord. In a parameter statute, my lord, the state has already defined recruitment year. I place it, my lord, but take my lord, my words, it is correct, my lord, from the record. Just now it is, I was searching for it, is misplaced somewhere. So now, my lord, kindly, if you, my lord, have it, this judgment, the honorable single judge has not gone into, my lord, at this juncture, I will take my lord to first para 28 of the 28. Let us start with 28, the conclusion first. What the honorable court has come to. So far the dispute, case 341, para 28 of the impugn judgment. So far the dispute of interest seniority between the petitioner in other
Para 28.
28 of the impugn judgment, my lord. That will be in my brief, it is 341 case.
The answer would be, in my humble opinion, the select this first came to existence, that will be set out in earlier.
Well, so far the dispute interest seniority between the petitioners in other 7 writ petition interest in those other direct recruits are concerned. The provision of Rule 17 are not as much clear as the respect of promotees inducted in vis-a-vis the direct.
I'm not getting it.
No, this is from the.
Yes, I got it. Yes.
Right. So far, para 28. So far, the dispute of interest seniority between the petitioners, other 7 writ petitions, interest with those other direct recruits are concerned. The provisions of Rule 17 are not as much clear as in respect of promotees to inductees vis-a-vis direct recruits.
No, because of this rules 15 or 17 you will refer. Yes.
Here in this case, interest seniority between 2 batches of direct recruits. It is stated by the state in their reply that the appointees selected pursuant to the advertisement number 6 of 15-16 are special drive recruits, and the appointees selected pursuant to the advertisement number 8 of 12-13 are general recruits. This is also factually not correct. Because within our segment, there are also reserve candidates were there. It is of course for the reason that advertisement 15 of 16 was meant for recruitment of ST category candidates only, whereas the advertisement 8, 12-13 was meant for all category of candidates, that is both unreserved and reserved. This is correct. But it is never stated in reply of the state that the vacancies notified for the advertisement number 6 of 15-16 are all such vacancies. For after the vacancies notified for the advertisement 8 of 12-13, However, I am not the said aspect of the date of vacancies. This is the, I want to take exception. What is mentioned in Rule 17 of the 2010 rule is that appointed to the service in a particular year, where year means a calendar year. The provision of Rule 17 of 2000 rule means it restated here that interest seniority of the officers appointed to the service in a particular year shall be in order of which their names appear in the select list. Of course, here are two select lists prevailing for two sets of direct recruits. Here is a case where two select lists are there, and the question is which select list is to be treated first in order. The answer would be, in my humble opinion, the select list first come into existence. In other words, the select list which was acted first has to be reckoned first in order, and in the instant case, it is the select list of letter dated 22/12/15 of the UPSC, pursuant to which appointment order dated 27/1/16 was issued first. The select list pursuant to the advertised 8/12/13 is dated 10/9/16, based on which appointment order dated 5/10/16 was issued. It is true, the principle of Meghachandra Singh and other supra has not been unsettled in Hariharan and other supra, despite the matter is referred to adjudication to a larger bench. Nevertheless, a question is for two sets of employees in the same cadre when appointed in the same calendar year. Their merit has to be ascertained in order of their appointments made in the same year. So the conclusion in which saw the light of the day earlier came to the existence earlier than the other who came later, and accordingly the persons appointed earlier are treated as senior to those appointed later. The submission of the private opposite party to stress the meaning of the word year as a recruitment year other than the meaning defined in section 21J of the rules is not found acceptable. So the seniority of the persons appointed to the cadre earlier in 27/1/16 and 18/5/16 are treated to be senior to the persons appointed subsequently in the same year. Thus, the impugned gradation list dated 11/6/2020, which is the subject matter of challenge, is in all the writ petition needs to be revised accordingly. In terms of the observation stated above, all the writ petitions are thus allowed, and the seniority of all such petitioners are to be refixed in the gradation list above the private opposite parties in the order that promotees inducted be placed en bloc senior to the direct recruits of the particular year, and among the direct
That is according to this rule 15 or 17.
16, all these things. But these are there, but the court has not taken note of. They are also not along with us in the same year, in a subsequent year. Two things from this.
The court has proceeded on the basis that the recruit or the year which is used in that particular rule means the year of an appointment.
Yes.
And if it is a year of appointment, so their appointment was prior in time and your appointment was admittedly after that.
Yes.
So the court says that it cannot be said that you will be put at a senior position. They are to be put in a senior position, recast according to the rules. First, the promotee first, then like this, you make an arrangement.
We will be in the bottom. That is the point. And in fact, the person, though we have filed the writ appeal, we could not get it.
What is a state's stand?
State stand when state was in our favor. But now the state action is, my lord, on 29/7. They are going to implement this judgment, my lord. Once it will, the 29/7, they have issued a notification by inviting objection on a tentative gradation list prepared accordance with the judgment. One will be implemented. So, my lord, will be
Tentative gradation list inviting objection.
Objection means what? You cannot go beyond the judgment.
There also, you were also beneficial. You challenged the gradation list. It was upset. So why you apprehend?
No, we never challenge. They challenge.
I mean, if the gradation list was already prepared, settled, it was made unsettled by the impugned order.
Yes, sir.
So it can further be unsettled by a distant bench order. No difficulty. Why you apprehend?
But they will do, because they will go by this order.
So let them go.
And now
they can't defy the order.
One more fact, we have got two promotions. After the SO, we became SO section officer. Thereafter, now we have been promoted also. So most of them, they might have got it also. Desk officer. The next promotion is desk officer. That is a problem. Two promotions we have got it. If this thing will be implemented, this judgment.
So you will not be relegated back.
Yes.
Yes,
My lord,
they
that is
will-
always, my lord, is that for our rescue, my lord. We cannot say that we cannot be relegated. But the humiliation part is also a part, man. That my lord is. And when my lord is.
There are judgments on that score that if you have already received the promotion and you cannot be relegated back.
My lord.
That's right.
But because now we are at 4:30, my lord. So we'll continue because I have the other judgment to show, my lord. And if
Where is the judgment of the Supreme Court in case of a judicial officer from the state of West Bengal?
that everything is, I will show in the next date, my lord, because it is hard, but I will give it.
Judicial officers.
Judicial officer's case,
I will give it. I will give it to the next date.
if I am not wrong, it is a Parthasarthi Sen versus the High Court of Calcutta. The same thing happened.
I am much obliged with that.
There was a recruitment process which was delayed for one reason or another. And there was a promotion which was already undertaken. Because it was the government, they did not permit the direct recruitment to a district judge entry level for nearly 30 years. The drive was initiated subsequently in 2009 and 10. And that was completed in 2015 and 16. In between 2009 and 15, so far as the normal promotions from the cadre was there, that continued. And those were filled. Then the recruitment drive was completed and they were posted. Then the question arose, they will be taken in the cadre for 2009, though their appointment was in 2014 or 15. And whether they should be placed above the position of a normal promotees or a jump promotees. Then there was a different views of the division and the full court. Sometimes some model, sometimes another model, and this create a confusion. Ultimately, the full court reviewed its own decision earlier. The challenge was made to the High Court. The challenge could not succeed. It says that your position would not be would be at this stage. Then one of them, the direct recruitees, they challenged the order to the Supreme Court. Supreme Court stayed it, issues notice, and thereafter decided. And the position was considered as that recruitment may be, appointment may be done on a particular day. But since their birth would be seen from the day when the cadre or the vacancy was there, so they are born into that cadre of 2009. In the meantime, certain promotees and the jump promotees, no, not jump promotees, promotees, they were already
Got promotion.
already came to High Court.
Oh, I see.
So, alteration, does it mean demotion?
Yes.
One of the judgment of our Odisha High Court went to Supreme Court, that 2010 Supreme Court. Itulakananda's case also. So it is a case of Sikha Sai.
So please find out that judgment, find out where once the promotion, I think their bottom, if I correctly remember the judgment, once the promotion has been extended and the person is occupying a promotional post, even if subsequently there is any change in the cadre or the seniority is upset, that promotional post.
This matter was carried to Supreme Court. The Supreme Court has already laid its view, say that promotions will go on, but all of them will be subject to result of the examination, and orders there on them.
Whatever is there, that is the difference. The promotion, that is a three-judge bench decision, I believe. Find out if you can.
Yes, we'll definitely.
I remember the fact, so I just.
Yes,
Yes, absolutely right.
After going back only, I'm part due to this. My lord, only what honorable submit my lord is
We have not heard
Yes.
What?
But
No.
the government action is, my lord.
What are yours? You have, what is the last date for inviting the objection?
That is, my lord.
Last date, my lord.
Yes, yes.
My lord, I don't know.
Yes.
I think the last date is 12th.
Well, 15 days they have sought it from 29/7, 15 days.
29/7 is the order passed.
15 days. 12.
27, 15 days time.
12.
It is all.
12.
12.
Yes.
12th is the
So I'm
last.
keeping this matter tomorrow. So that
My lord.
if we are satisfied, pass an order,
Fine.
interim order immediately.
My lord, I don't know. I don't know.
Tomorrow, my lord.
Let us see.
My lord.
Let us see. We continue.
Order 38.